I know that the whole House will have been horrified to hear the news of yesterday's air crash of Air India flight from Gujarat to London. On behalf of the House, I can express our deep sorrow this awful tragedy. I know that many colleagues have lost constituents and have suffered a devastating loss amongst those families, and they will be working tirelessly to support the families. Our thoughts are with them and their friends and the victims in India, the United Kingdom and around the world. I'm expecting ministers to come to the House on Monday to make a statement and an update on the Air India crash and about the events in the Middle East that's happened overnight. Right, the clerk will now proceed to read the orders of the day.
Terminally ill adults end-of-life bill as amended in the Public Bill Committee to be further considered.
Member in charge.
Now.
Before we begin, I would like to say a few words about today's proceedings. We will begin at the point we ended on Friday, the 16th of May, with the decisions to be taken after the debate on the first group of amendments. I will put the necessary questions without further debate. After that debate on the second group of new clauses and amendments that we then can begin, I remind honourable members that the scope of the debate will be the amendments and new clauses in that group. We have nearly 60 members who've indicated that they'll wish to speak in the debate. Not all honourable members will be called. It is not customary to impose a speech time limit on private members' bills, but I hope the member in charge of the bill and the speakers after her will restrict themselves in the early part of the debate, including taking interventions. The Chair will keep it under review as the debate progresses, and I will say now that if the Chair feels that people are taking advantage of the chamber, a time limit will be imposed. I hope we don't have to do that. I do not expect to call the front benches to speak till at least 1:15. I can also confirm that I provincially selected for separate decisions of all the propositions in the name of Kim Labita, the member in charge of the bill. I have also provisionally selected the following separate decisions on new clauses: Amendments B to New Clause 14, New Clause 1, New Clause 2 and New Clause 16. I will make further announcements on selection for separate decisions on amendments at an appropriate point. We will begin with the question that New Clause 10 will be added to the bill, which was debated on Friday the 16th of May. The question is that New Clause 10 be added to the bill. As many of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to New Clause 11, which was debated on Friday the 16th of May, has been selected for separate decision. I call Kim Labita to move formally that New Clause 11 be read a second time.
Formally.
Replacing the coordinating or independent doctor where unable or unwilling to continue to act.
The question is that New Clause 11 be read a second time. As many of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause 11 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to New Clause 12, which was debated on Friday the 16th of May and has been selected for separate decision. I call Kim Labita to move formally that New Clause 12 be read a second time.
Move formally.
Report where assistance not provided because coordinating doctor not satisfied of all relevant matters.
The question is that New Clause 12 be read a second time. As many of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause be added to the bill. As many of that opinion say aye. Aye. The contrary, no. The ayes have it. The ayes have it. We now come to New Clause 13, which it will be convenient to consider the other selected new clauses and amendments in Group 2 as listed on the selection paper. I call Kim Labita to move New Clause 13 be read a second time.
Move. Thank you, Mr. Speaker. Thank you, Mr. Speaker. It's a privilege to open today's debate and to present to the House the amendments tabled in my name, a number of which relate to issues I promised to return to when they were raised in committee. All amendments in my name have been drafted with technical advice and expertise from civil servants from the Department of Health and Social Care and the Ministry of Justice, along with a brilliant Government Legal Department and Office of Parliamentary Counsel, in order to make the bill workable and to give coherence to the statute book, as confirmed by the Minister for Care and the Minister for Courts and Legal Services in their recent letter to MPs. Some are technical and drafting amendments, and all are there to strengthen the bill. So I hope colleagues will be able to support these amendments wherever they stand on the principle of assisted dying. I know there are many colleagues who wish to speak today, so I will endeavour to speak with brevity, firstly to the new clauses in my name. Starting with new clause 13. Mr. Speaker, this important new clause and related amendments create a regulatory framework and safeguards around the approved substances referred to in the bill, by imposing a duty to make regulations about those substances and a power to make regulations about devices for use in connection with their self-administration. Amendment 72 provides that the regulations relating to approved substances are subject to the affirmative procedure, meaning they must be laid before Parliament and approved by resolution of both houses, providing important parliamentary oversight. Mr. Speaker, these amendments ensure that the substances used in assisted dying are subject to a specific and appropriate regulatory regime.
The member take an intervention.
I will.
At that point.
I will.
Patricia Ferguson.
Thank you, Mr. Speaker. I'm genuinely looking for clarification. As a former Cabinet Minister in the Scottish Government, I jealously regard the devolution settlement. And I just wonder how the extension of some of these clauses to include Scotland will be interpreted. And I'd like to know what conversations have taken place between the member in charge and Scotland's Lord Advocate, and also with the Scottish Government.
Thank you, Mr. Speaker. I thank you for that intervention. I've taken legal advice from government officials to ensure that devolution is respected at every stage in proceedings. So where legislation does need to be amended that affects other jurisdictions, those conversations have already started and will indeed continue. And no, I'm going to make some progress if that's okay. So in terms of the substances that would be used, there would not be new substances, Mr. Speaker. As we know, assisted dying is available in many other jurisdictions, and there are substances which have been used safely and in some cases for many years. Their safety and efficacy has been proven around the world, but they do need to be treated differently, which is the purpose of new clause 13. I'm going to make some progress, thank you. It's however most likely that these products are already licensed for other purposes, and they could well be regulated through the MHRA and within the human medicine regulations for the purpose of the bill. But it's important that time is given. I will give way.
Thank the Honourable Lady for giving way. As an ODP with more than 20 years' experience, I want to emphasise that controlling and administering drugs is already a really key part of every healthcare professional's practice. Medicines management is front and centre of everything we do when we're handling drugs. So does she agree with me that the safeguards added to this bill, along with the existing frameworks, are more than adequate to deal with these?
I thank her for that intervention, and I thank her for sharing her expertise, and along with other colleagues with medical backgrounds who have worked with me on this amendment. So, no, I'm going to make some progress. Given what the Speaker said. Mr. Speaker, I now turn to new clause 14. There's a lot of people who want to speak. I now turn to new clause 14 and amendment 73. This clause imposes a duty to make regulations prohibiting advertising of services related to voluntary assisted dying. This issue was discussed at Bill Committee following an amendment tabled by the Honourable Member for West Worcestershire. It was proposed that there should be no advertising of assisted dying services. I agree, and there was consensus on the Bill Committee about this. The previous amendment had some issues around workability, so I committed to returning to it at report stage, hence the inclusion of this new clause. Amendment 73 provides that regulations under new clause 14 are once again subject to the affirmative procedure, providing parliamentary oversight. I want to thank the Honourable Member for West Worcestershire. Yes.
Mr. Speaker, thank you. When it comes to the evidential base, just this week in the day's paper, Times newspaper, page 15, there's a story of a gentleman who was born in South Africa, lives in Australia, has come to London today and this week for this particular bill to give his story. His story is he was diagnosed with pancreatic cancer. For only 2 weeks to live. He lived for 3 years and 1 month, and he's still living. There's an evidential base that is growing. He said he was never afraid to die, but he does say he's afraid of the process of dying, which the Honourable Lady is the initiator of that. Would the Honourable Lady acknowledge the evidential base and the importance of this subject, and realise the evidential base against this bill is growing?
I thank you for the intervention. I'm not sure it's quite relevant to the banning of advertising in terms of assisted dying services, which I will try and stay focused on. I'm afraid I'm going to make some progress based on the number of people that want to speak today. So I want to thank the Honourable Member for West Worcestershire and the Member for Reigate for working with me on this amendment. I'm very pleased that they are supporting it. Moving on to New Clause 15 and Amendment 54. These amendments, These amendments make changes to the Coroners and Justice Acts that the bill would necessitate. They insert a new clause into the Act to provide that deaths that occur in accordance with the bill will be certified by an attending practitioner and medical examiner and will not be subject to a coronial investigation. Coroners, Mr Speaker, investigate suspicious deaths. I'm afraid not. Coroners investigate suspicious or violent deaths or situations where the cause of death is unknown. Assisted deaths would not fall into these categories, and there would therefore be no need for a default coronial investigation. This ensures avoiding any unnecessary delays and distress for bereaved families. Mr Speaker, these are not unexpected deaths. They were sadly inevitably going to happen. It is the manner and timing of their death, I'm afraid, about which the patient will make a legal informed choice, having been thoroughly assessed. As Professor Anise Ishmael has said, I cannot think of any death that will be the subject of greater scrutiny in advance of the person dying than an assisted death. The process far exceeds the level of safeguarding that is in place for many of the deaths that are at present routinely reviewed by medical examiners and not referred to a coroner. Of course, Mr Speaker, anyone can report a death, including an assisted death, to the coroner or indeed to the police if they have any concerns that it was not carried out in accordance with the Act. And if any offences have been committed, they will be investigated. Section 2 of New Clause 15 requires that the medical certificate of cause of death must state the death as an assisted death, but must also record the illness or disease which caused the person to be terminally ill and enable them to receive assistance under the Act. This is really important for data collection and monitoring. In jurisdictions with similar legislation, around 70% of patients have some form of cancer, and this amendment would ensure that data was collected not only in relation to how many people access assisted dying, but also the terminal illnesses which make them eligible. I now come on to New Clause 20, which relates to the guidance about the operation of the Act, including with respect to devolution. Put simply, Mr Speaker, New Clause 20 ensures that the right roles and responsibilities sit with the right people. It firstly puts the obligation to issue guidance with the Secretary of State, and secondly enables Welsh ministers to issue guidance on devolved matters. The Secretary of State must consult the Chief Medical Officers in order to have the benefit of their expertise, which is also really important. New Clause 20 also adds provision which ensures that the Secretary of State must consult people with learning disabilities and people with protected characteristics, which includes disability, race, religion and belief. I'm going to make some progress, I'm afraid. And they must also consult providers of health and care services. This includes palliative and end-of-life care. And I'm really pleased that Hospice UK are supporting this amendment. It's very important that those voices are heard. The Secretary of State can also consult anyone else they feel to be appropriate, creating a flexible and holistic approach. Coming on to devolution. Mr Speaker, this long overdue reform would apply to England and Wales, which share a criminal justice system. Health is, of course, devolved, and I've recognised from the outset that the legislation must respect devolution, and I'm fully committed to observing the same conventions that government would if this was a government bill. I've worked with UK government officials to ensure that the right steps are taken at the right time by the right people. I've engaged with colleagues in the Welsh Government. I met with the Welsh Health Minister in Cardiff, and there have been ongoing detailed discussions between the two teams of government officials to ensure workability of the legislation in both jurisdictions in line with the devolution settlement. Amendments 92 to 94 also ensure that the devolution settlement is respected and adhered to. Mr Speaker, I want to thank the honourable members for Dwyfyn Marenid and Cheshire and Amersham, not only for their diligent work on the Bill Committee, but also for working with me on the amendments in relation to Wales, and the Welsh Government for their guidance and support. And I hope colleagues across the House can support these new clauses and amendments. I now turn to New Clause 21, which makes specific provision about the use of the Welsh language. Mr Speaker, the conversations that happen at the end of a person's life are extremely personal and should be handled with the utmost sensitivity. It's very important that they are conducted in the best interests of the patient, and a big part of that is by using clear communication. And in this respect, language matters. So if a patient in Wales has Welsh as their first or preferred language, all efforts should be made to ensure they can communicate with voluntary assisted dying services in Welsh. I committed to this at Bill Committee and have made good on that commitment. Coming on to Amendments 76 and 77. As with any bill, it's important that the amending legislation to secure secures overall coherence with the statute book. As such, the clauses relating to medicines, advertising and employment protections amend or confer power to amend other legislation that currently extends to parts of the UK. This doesn't mean the provision of assisted dying, of course, but, for example, it extends the prohibition on advertising to the whole of the UK and provides the employment protections in this bill to Scotland. This is the guidance I've received from legal experts, and as such, I hope all colleagues can support these amendments. And Mr Speaker, if the bill passes, in the same way as I've worked with the Welsh Government, if necessary, I will work with other devolved administrations to ensure devolution is respected. Mr Speaker, that concludes the explanations for the amendments tabled in my name. And I know there are many colleagues that are keen to speak on the debate today, so I'm not going to comment on all amendments in the group, but I will just make 2 comments on amendments which are not in my name, allowing other people plenty of time to speak. Amendment 42 from the member for Newcastle-under-Lyme not only tries to remove the backstop for the provision of assisted dying in England, but it also creates a number of other issues in relation to commencement. If Parliament chooses to give this choice to terminally ill people, there cannot be a clause in the bill that would prevent it being available as soon as it is safe and practicable. But this amendment would remove the 4-year backstop. It would also prevent the appointment of the Voluntary Assisted Dying Commissioner and create a potential commencement gap between England and Wales. As such, I've been strongly advised that this amendment would create serious workability issues, and I urge colleagues who want an operable bill to join me in rejecting it. To finish, Mr Speaker, I'm pleased to support Amendment 21 from the Honourable Lady for Twickenham, and I want to thank her for her engagement with the bill and this amendment, which would require the Secretary of State to prepare and publish an assessment of the availability, quality and distribution of palliative and end-of-life care as part of the first report on the implementation of the Act, mirroring the assessment already required as part of the 5-year review. Mr Speaker, whilst the bill seeks to address what in some respects is a very specific issue in terms of the failings of the current law, it has become part of a much needed broader conversation about death, dying and end-of-life care. We all have our own experiences of death, loss and grief, and it's something we don't talk about enough. I'm really pleased that this bill has led to many conversations up and down the country, which, whatever your views are, has got to be a positive thing. Mr Speaker, I've had many such conversations over recent... I've nearly finished. Mr Speaker, I've had many such conversations over recent months, including with palliative care doctors, nurses, hospice staff, GPs, Hospice UK and Marie Curie, who are supporting this amendment. And I would like to thank them all for their constructive engagement with the bill. I cannot imagine there is anyone in this place who is not truly grateful for the outstanding work done every day by the wonderful people working in palliative and end-of-life care in every one of our constituencies. Many, if not most of us, will have personal experience of the kindness and compassion they have shown to our own family and friends. But this is not an either-or conversation. Palliative and end-of-life care and assisted dying can and do work side by side to give terminally ill patients the care and choice they deserve in their final days. So in the same way that this should not be an either-or for dying people, it should also not be an either-or for us as legislators to choose between supporting assisted dying or other end-of-life choices. And that is why I'm supporting Amendment 21, to ensure that we channel our energies in this place into supporting all options available to terminally ill people, something which I have always committed to do. Thank you, Mr Speaker.
Regulation of approved substances and devices for self-administration.
The question is that new clause 13 be read a second time. Sarah Olney.
Thank you very much, Mr Speaker. It's a privilege to be called at this stage in the debate. My principal reason for voting against the bill at second reading was my concern that vulnerable people would be put at risk. I agreed to serve on the Bill Committee so that I could do what I could to allay my concerns about this and address some of the issues that were raised by others. I do not think that the revised version of this bill properly or completely reflects the concerns expressed on a multitude of different occasions and consequently does not fully mitigate the risks to vulnerable groups. We all recognise that decision-making of any kind does not take place in a vacuum, and that in all parts of life we live in a particular context. The Equality Act 2010 recognises that many people face discrimination or unfair treatment as a result of particular characteristics, and that reasonable steps should be taken to eliminate this. It was very clear from the oral evidence sessions that particular care has to be taken to assess the context within which people are making the decision to seek an assisted death. if they suffer from a mental illness or an eating disorder, if they're from a low-income or ethnic minority background, if they suffer from a disability, or if they are in an abusive relationship. These factors are likely to lead to an increased risk that someone will seek an assisted death, which they would not have sought if those factors were not present. The point was made by myself and others during the committee stage that it would have been desirable to have received an equalities impact assessment before the detailed work of committee scrutiny had begun, so that the committee members had a sense of how the proposed legislation would impact those groups that we know can suffer at disproportionate levels of disadvantage. We were told it wasn't practical to produce it until, I won't if that's okay, wasn't practical to produce it until after the committee stage because it would be necessary to assess the impact of the amendments made during committee. So the impact assessment was finally published 5 weeks ago, Mr. Speaker, and I have to say, I was pretty astounded. The Equalities Impact Assessment makes no recognition of the fact that certain groups in this country may have their lives prematurely shortened as a result of this legislation passing. It concerns itself instead with the barriers that vulnerable people may face when trying to access assisted dying, and I find this astonishing. Did the people who drafted this assessment not hear the speech of the member for Vauxhall and Camberwell Green during the second reading debate, when she spoke with passion about how the underlying inequalities in access to healthcare experienced by those from black and minority ethnic backgrounds would be exacerbated if this bill passed unamended? Did they not listen to the oral evidence of Dr. Jamila Hussain during the committee stage, where she talked about her experience of working with racialised communities in Bradford and their fears of being pushed disproportionately towards an assisted dying pathway? Or the testimony of Dr. Miro Griffiths on the experience and concerns of disabled people, testimony which has been echoed by Baroness Tanny Gray-Thompson and the actress Liz Carr. It is inexplicable to me that the impact on vulnerable people should be framed as removing barriers to accessing assisted dying and not, as it should be, the increased risk to their health and well-being that the passing of this legislation presents. And I am concerned that we are thinking about the impact on vulnerable people solely with reference to those who are suffering a terminal illness with fewer than 6 months to live. We are not thinking about the impact on our wider society of introducing a concept of lives not being worth living and how that might disproportionately affect our more vulnerable communities. So my new Clause 19 and consequential new Schedule 2 and Amendment 88 seeks to ensure that a comprehensive range of statistics are collected about those who seek and receive an assisted death, so that proper and complete monitoring of requests can be carried out. It is absolutely imperative that we get the most detailed possible picture of who is requesting an assisted death, so that any patterns of disproportionality can be properly detected and addressed.
On that point.
Very briefly.
Thank Honourable Lady. And on the point of disability and those with mental health issues, those who are anorexic, those who perhaps need family assurance when it comes to this, what assurances does this bill give to the families of those people? I don't see any in it. Does the Honourable Lady see any assurances for those who want to end their lives but who suffer from those ailments?
Sir Alden.
I welcome that intervention. I spoke extensively about the impact on anorexic people of this bill, and I am not satisfied that those concerns have been addressed. I've been pleased to support Amendment 21 by my good friend, colleague and constituency neighbour, the member for Twickenham, which has attracted support from across the House and requires the Secretary of State to report upon the impact that this Act has had on the healthcare available to those with palliative and end-of-life care needs. I'm really pleased that the member for Spen Valley has agreed to accept this amendment. I'm also pleased to be supporting the amendments in the name of my other constituency neighbour, the member for Wimbledon, Amendments 103 and 104. These amendments seek to make all statutory instruments under this Act subject to the affirmative procedure rather than the negative procedure that is currently provided for. As it currently stands, this Act, once passed, will come into force in 4 years' time with no further scrutiny from MPs. And yet there are a whole host of issues that have been delegated to the Secretary of State or not even considered that will need to be legislated for after this bill has received its royal assent. As the bill currently stands, the only way for Parliament to scrutinise these powers are to call for a 90-minute debate on a motion that cannot be amended and will only be voted on if the Leader of the Opposition calls for a vote. Converting the negative resolution to an affirmative resolution means that the Secretary of State, whoever it is, can only exercise the powers delegated to them with the approval of Parliament. For an issue as sensitive and as profound as assisted dying, I believe that to be an appropriate level of scrutiny. In a similar vein, I will make some progress, sorry. In a similar vein, I plan to support the amendments in the name of the member for Tonbridge, which seek to remove all Henry VIII powers from the bill and from the amendments introduced by the member for Spen Valley. I will support those amendments if selected for a vote, as I do not believe that the use of Henry VIII powers is appropriate or necessary. Mr. Speaker, I want to speak against Amendment 94 in the name of the member for Spen Valley. It appears to be an innocuous amendment, but in reality it reverses the effect of an amendment that I tabled and had accepted in committee stage. The bill, as originally drafted, creates an enormous constitutional minefield. The bill seeks both to amend the criminal law of England and Wales, which is a reserved matter for the UK Parliament, but simultaneously to make provision for healthcare, which is a matter devolved to the Senedd in Wales. Furthermore, the Senedd debated a motion calling on the Welsh Government to support the principles of assisted dying, but this was defeated by 19 votes to 26. This was a non-binding motion, but it does demonstrate that this bill gives the UK Parliament the power to impose on the Welsh Senedd a measure that it has expressly said it doesn't want. The bill, as amended by committee, gave the power to the Welsh Senedd to decide for itself when it was ready to bring the bill into force. Amendment 94 reverses that provision and deprives the Senedd the right to exercise its legitimate powers. It is not just that Amendment 94 restores a constitutional loophole that the committee had closed, it threatens to create real problems and risks for Welsh citizens if the Senedd are forced to implement the Act before their devolved healthcare system is ready. So I urge fellow members to have regard to the committee's decision in this regard and vote against Amendment 94. I will speak briefly in favour of a couple of other amendments. I remain highly concerned at the idea of a future Secretary of State having the power to change the NHS Act, and very specifically Section 1, which sets out the purpose for which the NHS exists, using regulations instead of an Act of Parliament. Once that power exists, it can be used not once, but at any time, to make fundamental changes to what our NHS is for. I was dismayed to see a change of this magnitude made to the bill in committee, and I'll be voting for Amendment 12 in the name of the Honourable Member for Mitcham and Morden to reverse it. Amendment 42, in the name of the member for Newcastle-under-Lyme, seeks to remove the automatic commencement of this bill after 4 years. For the vast majority of Acts of Parliament, the Secretary of State decides when to bring the key provisions into force rather than it happening automatically. The effects of the provision of this bill is that even if we have a future COVID pandemic or the Secretary of State realises that the adequate training has not yet been completed, then it will still come into force, come what may, after 4 years. This is not safe. It is unusual and reckless, and for that reason I support Amendment 42. Amendment 13, in the name of the Honourable Member for Glasgow West, would require the appointment of the new Voluntary Assisted Dying Commissioner to be approved by the Health and Social Care Committee. The Commissioner, a role created from scratch, will be a high-profile, influential and important position. Adding a second layer of approval will add more rigour to the appointment process and provide transparency in the event of any problems that arise. It is vital that members of this House have the opportunity to scrutinise and debate that new role, which was not included in the bill at second reading. I thank you very much, Mr. Speaker.
Stephen Sanders.
Thank you, Mr. Speaker, for allowing me to rise in this debate and speak to new Clause 6. This clause proposes a special representative for ethnic minorities. Now, I am not white, Mr. Speaker, and some of you may have noticed. The fact that my presence in this House is unremarkable is in and of itself remarkable. And that did not happen by chance. It happened because of those that came before me. Now, the mother of this House has spoken powerfully in this debate, and I know that my unremarkable presence here is due to her remarkable achievements. We may not always hold the same opinions, but we have always shared the same Labour values. She will never know how grateful I am, we all are, for her. I may be the last generation of MPs that can say this to her while she is in this House. Thank you. The member for Vauxhall has spoken powerfully in this debate. The member for Walsall has put this amendment forward. I know I stand on their shoulders too. And I don't doubt their good intentions. But this bill has nothing to do with the colour of my skin. New Clause 6 proposes a special representative for ethnic minorities. I disagree with this clause because the colour of my skin has no bearing here, no special place in this debate. Equalities Act for this Act would be reported to the ECHR as set out in Clause 51. The Secretary of State can already consult with community representatives. For every person of every skin colour, this bill gives the already dying a choice to end their suffering.
Can I just say, we do need to make sure they're always tied to the amendments. So it's not just about the generalisation, which is important. We've gone past that. I think this is more a third reading speech you might want to have said.
Mr. Speaker, it is to the point of where we are.
I better sit down. I make that decision. Please don't challenge the chair. Jameson.
I do apologise, Mr. Speaker. What I meant to say was this clause is around a special representative around ethnic minorities, and the point I am trying to explore is why it is that for ethnic minorities we do not require a special representative, that actually it's included within the Act, within Clause 51. And to the point of it all, I will give way.
I thank the Honourable Gentleman for giving way. This is a very sensitive issue. There is data to support the fact that people from minoritised ethnic groups are less likely to trust their health professionals. While it's 18% amongst the general public, it's as high as 30%. Do you not think that it is necessary to have, does my honourable friend, Mr. Speaker, does my honourable friend not think it is necessary, therefore, to make sure there are additional protections for those who face additional barriers, such as those from minoritised ethnic groups?
The member raises a really powerful point. Members, as the member has, have spoken really powerfully about the impact on ethnic minorities this bill could have. Does anyone in this House know how many ethnic minorities access assisted dying in other nations? I will give way on this point. The member for Richmond Park raised it earlier.
Sir Olney.
Calls me to speak. If we don't know, it's probably because they're not collecting the data. My position is we should be collecting the data, and that is why you should vote for my Amendment 19. Thank you, Mr. Speaker.
Mr. Speaker, we do know. Ethnic minorities are less likely to access assisted dying in the jurisdictions it is in place. In Oregon, 10% of those using or accessing assisted dying are ethnic minorities, compared to 40% of the population. In California, 15% of ethnic minorities access this option, compared to making up 30% of the population. But that is not the point. The point of this bill is to give the people the choice to end their life regardless of the colour of their skin. There is no special quality about the colour of my skin that affects my access or the need for a special representative in this case. A case that is covered by the ECHR, that is covered in the Secretary of State. I will give way to my member over here.
I thank the Honourable Member for giving way, and I'm quite perplexed with his speech actually, but nonetheless I'd like to understand, does he have the data to reflect when he's related to those jurisdictions, the actual demographics of those constituencies, of those areas in comparison to the UK? Please present it to the House to support his arguments.
I've spent a lot of time around data, Mr. Speaker, and I'm really not sure I understand the question being asked. It is the case. I think I'll make a little bit of progress if that's okay. I know this has been a heated debate. I know that people feel strongly on each side of this House. And I'm so grateful for members who have come here before me, who made my place here possible, who have spoken so powerfully and so movingly in this debate. But I do not believe, and the evidence shows, that the colour of my skin does not belong in the discussion of this bill. Thank you, Mr. Speaker.
Rebecca Smith.
Mr. Speaker, I rise today to speak in support of Amendment A to new Clause 15, which is in my name, and which I hope honourable members will feel able to support. Although it seems technical, it is in fact a simple amendment with a significant impact with regard to ensuring genuine protection against abuse, proper detection of coercion, and effective scrutiny of how the law works in practice. Simply put, the effect of my amendment is to ensure that deaths from assisted dying under the bill will still fall within the coroner's duty to investigate deaths under Section 1 of the Coroners and Justice Act 2009, and I will explain why that is so important. Mr. Speaker, like many colleagues, I have been deeply concerned from the outset about how this bill is drafted, its workability, its impact on the NHS, and indeed the lives of vulnerable people up and down the country. To be clear, my own view is that one unintended death as a result of this bill becoming law is one too many, and I would humbly ask colleagues who are still considering their position, or indeed who are minded to support this bill, to consider this point about my amendment very carefully in the round. What is an acceptable error rate? Based on the figures in the government's own impact assessment, which I think underestimates the impact, even a 1% error rate would see a minimum of 13 wrongful deaths in year 1. With 45 per year by year 10. A 5% error rate would see 65 deaths in 1 year and 227 in year 10. And a 10% error rate would see 131 deaths in year 1 and 455 in year 10. As I say, I think these are lowball estimates, but they are nevertheless chilling. If this law is passed, it will be exceptionally difficult to say whether or not there have been errors or instances of abuse, or at the very least, any errors which are picked up will be but a fraction of the true picture, as tragically those who would testify to this fact will already be dead. So my new clause A to new clause 15 directly addresses this issue. In England and Wales, a coroner will investigate a death when certain legal conditions are met. This duty is primarily governed by Section A of the Coroners and Justice Act 2009. His Honour Justice Thomas T. KC, who served until 2024 as the Chief Coroner of England and Wales, notes that any death arising as a consequence of the ingestion or administration of a lethal substance constitutes an unnatural death which the local coroner is under a statutory duty to investigate. Clearly, assisted dying meets this definition, and it is right that such deaths be afforded the best possible posthumous judicial scrutiny. I will give way.
Lizzie Collins.
Thank you, Mr. Speaker. I appreciate the Honourable Lady giving way. Does she not feel that the provisions in the bill already have the safeguards in, but also, and most importantly, does she not feel that putting a family through a coronial process when it is an expected death is unfair, unjust, and completely beyond the bounds of what the coroners are actually meant to do? Thank you, Mr. Speaker.
On the first point, I don't believe that the law is strong enough as it stands in terms of this bill. But on the second point, we're already dealing with the fact that families aren't even guaranteed the knowledge that their loved one is going to have an assisted death. So I think her point is not entirely to be considered. However, as it stands, Mr. Speaker, the bill would disapply the duty of the coroner to investigate in the case of an assisted death that has been carried out in accordance with the bill's provisions. New Clause 15 specifically would amend the Coroners and Justice Act 2009 to clarify that assisted death does not constitute a natural death for the purposes of the Act. I must say that I think it takes an extraordinary leap of imagination not to conceive of deliberately self-administering lethal drugs as anything but an unnatural death. I will.
Thank you to the Honourable Lady for giving way. I want to support her in what she's saying. We are going through a process as we consider the appalling situation of coercive control in domestic abuse situations, where a person who is a victim may not realise they've been a victim until years later. Obviously, a person who has gone through an assisted death will have no years later. Isn't this a way of making sure that we guard against the evil of coercive control?
So I thank my honourable friend for his intervention, and I completely agree with him. This is the sort of safeguards that even the sponsor of the bill is saying should be there. I don't think they are, and this amendment to New Clause 15 is to put that in a much stronger position.
Will my honourable friend be right?
Yes, I will.
I'm very grateful. She's right in what she says, because just as those of us who are opposed to the death penalty, we are against it, because we do not believe in the infallibility of the state. The state can get things wrong. Professionals can get things wrong. And when they do, there should be a proven, clear path as to how that wrongdoing can be identified and try to ensure that it doesn't occur again.
Yes, I thank my honourable friend for that, and I think the statistics I quoted earlier on in my speech are pretty clear to the point that he has just made. I'll make some progress, Mr. Speaker. The work undertaken by the coroner is not a box-ticking exercise or a bureaucratic hurdle. In the context of assisted dying, it is an extremely powerful deterrent against abuse or malpractice. Again, to quote His Honour Thomas T. KC in a letter to the Times on the 7th of May this year, he said the removal of any realistic prospect of an effective inquest would magnify rather than diminish the obvious risks of deception and undue influence. I struggle to see... Oh, yes, I will, good way.
Making a very powerful speech. Does she also share my concerns, as the Royal College of Pathologists have clearly stated in their statement about the removal of the coroner, which would speak to her amendment?
I thank the Honourable Member, and I will come into that very soon in my speech, and I will now make some progress. I won't take any further interventions. I struggle to see how this squares with the commitment to enact legislation with the strongest safeguards in the world. By removing automatic oversight of assisted deaths, the bill sets a lower bar for scrutiny and review and creates an information deficit. Put another way, we simply don't know what we don't know. Implementing a novel piece of legislation such as this without ensuring the most robust possible scrutiny of deaths taking place under the Act is astonishing. Under this bill, assisted deaths will be the outlier, as any other intentionally procured death would automatically be reviewed by a coroner. Why should deaths under this Act be any different? Requiring automatic scrutiny from a coroner for assisted death should not be viewed as an add-on at the end of the process, or perhaps just a safety net, though it is that. Rather, it is imperative to... No, I've already said that I'm not going to take any further interventions. I've been very generous with my time. I made it very clear. Rather, it is imperative to consider the whole picture, particularly regarding malpractice or coercion, whether that is on the part of medical professionals, family or third parties. In written evidence to the committee, Dr. Rhys Johnson, a legal expert from Essex Law School, highlights that in some cultures, decision-making is a collective process involving family and community members. This approach, combined with the bill's provision for signing by proxy in Clause 19, potentially creates opportunities for coercion or abuse, particularly where family members have conflicting financial, social or emotional burdens. Without a coroner's inquest, Dr. Johnson notes, we would lose the ability to fully and properly investigate the possibility of where coercion or abuse took place in such culturally sensitive situations. Investigation of assisted deaths by coroner is not a luxury, it is a vital safeguard, without which people will fall through the cracks. No. Beyond coercion, automatic inquests provide vital opportunities to identify other critical issues which may not otherwise be picked up. Without a coroner's inquest, there would be no post-mortem examination. This is not merely an academic point. Studies have shown that 1 in 4 cases had been misdiagnosed after autopsy. Without this oversight, as His Honour Judge Thomas T. Casey, the former Chief Coroner, notes, there is no certain means of knowing whether the approved substance has led to a quick and painless death or a lingering and distressing one, and even whether it had failed to cause death altogether and the deceased had been dispatched by manual asphyxiation or some other unlawful means. I am not sure it could be more clear, Mr. Speaker. The view of the experts in this area, both the Royal College of Pathologists and the former Chief Coroner of England and Wales, is that this bill's proposals, as drafted, are not fit for purpose, and I strongly urge honourable members to support my Amendment A.
Can I suggest we aim for around 6 minutes informally, and a good example with Paul Ward?
Thank you, Mr. Speaker. I rise to speak in support of the amendment in my name, which seeks to strengthen new clause 14 in the name of the member for Spen Valley. Why do we want to restrict advertising about assisted dying? Not just because such adverts could appear crass or insensitive, not just because we worry private companies could profiteer from death. It's because advertisers know they influence choices. And the issue of choice, whether it's informed choice or skewed choice or self-coercion or coercive control, as already mentioned, is in many ways at the heart of this bill and whether its safeguards are sufficient. My brother works in advertising and he knows its power. It's why companies spend billions of pounds on it. It's why Google is the giant it is. It's why you'll see lots of adverts at Westminster Tube Station trying to influence every single one of us. It's why X is full of ads. Advertising works because we human beings are suggestible, prone to messaging, to visual cues and hints. Older people are bombarded with adverts for everything from stair lifts to care homes. One person's advert, though, is another person's public information campaign. It's not impossible to imagine a Secretary of State in future who passionately believes in the merits of assisted dying to authorise such a campaign. It could be a government-approved plotline in a soap opera. It could be an ad read out by a podcaster that ever so subtly sounds like it's a news item or even their own opinion. Many in this House rightly try to protect teenagers from online harms. But the online harm of an ad for a website about assisted dying shared on TikTok could be a reality without the tightest safeguards of my amendment. I do give way.
Anna Dixon.
I thank the honourable gentleman for speaking so clearly about the issue of advertising. Will he recognise that the reason this country has banned advertising of pharmaceuticals is so that we're not in the position that they have in America, where people are popping pills all the time? That is the reason we're protecting patients, and we need to do the same with assisted dying.
Paul Wall.
I completely agree with my honourable friend, and the dangers of what's done in America are a real lesson for us here. Now, as the Honourable Member for Reigate put it, conversations about assisted dying should happen in person between the relevant doctor and the patient. They should not be prompted by a TV ad or something seen on a bus. And my honourable friend, the Member for Bexleyheath and Crayford, also spoke very movingly about the way that IVF services have been commercialised, leaving people who are, as he says, already on their knees and vulnerable to exploitation so that someone else can profit. I'm certain that it would be the intention of nobody in this House that passing this bill into law should mean the rise of a similarly aggressive market for assisted death. But it's our role, indeed it's our responsibility to deal not only in intended consequences, but in unintended consequences too. And I think the real risk to the way New Clause 14 has been drafted to allow exceptions that are not specified on the face of the bill. A future Secretary of State will be empowered not only to make the necessary regulations, but to amend them at any time. And a future Secretary of State who does not share the concerns of this House would have the ability to draw the exceptions so widely as to make the ban worthless. There are a number of similar bans in advertising already in place on tobacco products, on surrogacy, on the latest cancer drugs being marketed to the public. In every case, the legislation sets out the exceptions, leaving no room for doubt as to how Parliament intended that the public should be protected. Why should the services that this bill would legalise not be subject to that same legal clarity? Do people who have less time to live not deserve all the protection we have the power to give them from a death they do not truly want? I cannot believe this Parliament would be content to have that power taken out of its hands and the rights of our most vulnerable constituents left for someone else to decide on some other day. My amendment therefore sets out that exceptions to the advertising ban should be limited to cases where a person has requested information and cases where the materials are intended for health professionals and not for their patients. New Clause 14 allows a future Secretary of State to make provisions that would usually have to go through the House in legislation. It's not at all clear to me why this power is needed in order to introduce a ban on advertising. I will give way.
Sir John Hayes.
I'm very grateful to the gentleman. I entirely support his argument and his amendment. This is the difference between, in the mover's estimation, accepting a request and promoting a service. Advertising is about the promotion of a service to doubtful, fearful and vulnerable people, and that's precisely what his amendment addresses.
I agree with the honourable gentleman, and there's a wider point here. This is about the Henry VIII powers that are in this bill. And there would be one-third of those added to the bill. This would be the third Henry VIII power added to this bill since second reading. At that stage, at second reading, it had none. The Attorney-General Lord Hermer has said that excessive reliance on these Henry VIII powers upsets the proper balance between Parliament and the Executive, and he's right. But away from matters of constitutional principle, I'm especially concerned that a practical impact of such a power would allow a future Secretary of State to change the law as set out in the Suicide Act of 1961. This is the act that contains the offence of encouraging or assisting a suicide. Ministers have confirmed that the bill, as drafted, leaves the offence in place in all cases except where a medical practitioner assists a person to die under provisions of the Act. We must surely therefore not hand the power to a future Secretary of State to weaken or even abolish that offence without the need for primary legislation. My amendment therefore specifies that the Suicide Act cannot be amended in this way. I hope that my honourable friend, the member for Spen Valley, will recognise my amendment does not seek to undo or undermine her own amendment, but rather to build on it, and also to ensure the ban she intends to deliver doesn't collapse around the loophole at its heart.
On that point,
Yeah.
I thank him for giving way. Thank you, Mr. Speaker. I think he's making a really powerful point, and I think there is consensus across the House around banning advertising of assisted dying services. His amendment, there would be slightly limited in it. It just makes 2 exceptions, and there would probably need to be a broader piece of work to be done around that, but I would commit to working with him on that if he's interested.
Paul Wall.
I think the point of my amendment is to make sure that a future Secretary of State would have to come before this House with primary legislation. Now, the report stage of this bill is not about the principles of this bill. It's not about whether a member may in principle support the idea of assisted dying, as the Mr Speaker will point out to everybody who strays from this amendment. It's about this individual bill before us today. We have to ask, what will it mean in the real world for our very real constituents? I won't give way, I'm short of time. Just how strong are this bill's safeguards? We're not commentators, we are legislators. Our job is to scrutinise, to test and test again the bills that come to this place. I spent 26 years up there in the press gallery writing about politics, but the big difference between them and us is that we have a vote in this place. And with that vote, particularly a free vote, comes responsibility. And there's no greater responsibility than protecting the vulnerable from feeling they have to end their life. And that's why I've tabled this amendment today. I'm not driven by religion, though I don't believe that those with religious faith should be denigrated or patronised as they have been during this bill. It's worth saying that some of those who passionately support assisted dying often have a faith, a devout faith, that their worldview is the right one. I'm driven instead by my duty as a legislator to get this bill right, and by what I see as my moral duty to protect the most vulnerable in society. I believe my duty is to protect those who don't have celebrity names or campaign groups behind them, the people who don't get heard, who don't want to be a bother, who don't want to make a fuss, who feel at the end of their lives they're a burden on their family but may never say so. I worry about the unheard, the unseen, the ignored and the marginalised. Most of all, I worry about the heartbreaking modesty of that phrase you often hear from older people, I don't want to be any trouble, love. We need, for their sakes, to make sure the safeguards in this bill are the strongest they can possibly be.
Dame Caroline Down.
Mr Speaker, I only intend to speak quite briefly, but I really wanted to start by saying we have to be really honest about where we are, the current situation, the legal status quo. It's not working. It's failing terminally ill people who want choice, compassion and control at the end of their lives. Right now, those with the means are travelling abroad to die, often alone, without medical support, away from their loved ones, and often at a time that they can physically make it rather than the time of their choosing. And those without the means face suffering they don't want, or they try to take matters into their own hands here in the UK unsafely and illegally. It's not humane, it's not fair, and it's not sustainable. Mr Speaker, I spent 2 years as a Minister in the Department of Health, and palliative care and end-of-life care was part of my portfolio. So this was something that came across my desk on a regular basis. It's something I had a lot of time to think about, and it's something that is not easy to find an answer and a solution to, but I do think we owe it to people to try and do that. That is why I support this bill, because it brings this issue out of the shadows and into the framework of regulation, safety and dignity. Because I will give way.
To the right honourable member, I don't know if she's had time yet to read the Independent Palliative Care Commission's report, but it goes into how pain can be palliated, how symptoms can be palliated, and ultimately the problem at the moment we've got is poor care and the poor provision of specialist palliative care palliative services. Will she read that report and understand the difference that palliative medicine can make for all of those examples of poor care we've heard in these debates?
Dame Caroline Down.
I certainly will read that debate, and she makes an excellent point. Palliative care is really important. It needs to be improved, and in many, many cases it can make such a difference. But it is not the solution for everybody, and there are cases, most heartbreaking cases I've met in my own constituency, where that form of palliative care would not have made the difference, and that's why I support this bill, and that begins with new clause 13.
I wonder if you can assist me. I'm at a loss as to what amendment we're discussing.
Well, the honourable member no doubt gives the member speaking a moment. She'll address it very quickly because members don't have long to contribute, even when they are contributing.
Thank you much, Madam Speaker. I'm addressing new clause 13. This clause provides the strict regulation of life-ending substances and self-administering devices. That means transparency about what substances are used, how they're stored, prescribed and delivered. We owe it to patients, clinicians and the public to ensure that every part of this process is governed by clinical standards and ethical safeguards. And for those physically unable to swallow or self-ingest, this clause also ensures that devices to support self-administration can be safely used. Without that, we risk creating a system that excludes some of the very people it's meant to support. But while we must regulate this properly, we must also reject amendments that will undermine or stall the bill's delivery. Amendment 19 proposes adding suicide prevention, the Mental Health Act and deprivation of liberty safeguards to the Code of Practice. As the Minister who put so much of that legislation through, those are really, really important topics, but this is not the legislation to address them. Let's keep the code focused on the bill's core function, ensuring a safe, consistent and compassionate assisted dying process. Amendment 20 would allow non-adherence to the code to be used in civil or criminal proceedings. This is not appropriate. Guidance is meant to help professionals navigate difficult decisions, not to become a legal trap. If clinicians act negligently, existing law already applies. We should not be creating new liabilities for those who are acting in good faith in very difficult conditions. I also oppose Amendment 97 and 27, which would require MHRA to license drugs specifically for assisted dying, and NICE to recommend them. That would make this bill unworkable. I'll give up very briefly.
For giving way. Does you share my concerns that the impact assessment associated with this bill says that the safety and efficacy of those substances used for assisted dying is currently difficult to assess?
Well, I'm not entirely sure that I do agree with that, but I really want to talk about the MHRA because it just isn't set up to license drugs for ending life. Clinical trials to support this kind of license, an MHRA requirement, would be impossible. However, the substances likely to be used are already tried and tested in other jurisdictions and MHRA approved for other purposes. So new clause 13 already provides us with strict regulation we need without putting prohibitive hurdles along the path to a compassionate, painless death. And finally, Madam Deputy Speaker, very briefly on Amendment 42, would remove the backstop date for implementation, giving the government indefinite discretion over when or whether to put this law into effect. That can't be right. If Parliament passes this bill, there must be clear, reasonable time frame for implementation. The 4-year backstop already gives government more than enough time to get this right. Removing it simply invites delay. Mr. Speaker, Madam Deputy Speaker, I do apologise. This is a moment to show that we can both be compassionate and competent, that we can bring an end to the quiet suffering caused by an unjust status quo and replace it with a system that is safe, fair and accountable. Let's support new clause 13. Let's reject amendments in this bill in red tape will stall its progress, and let's show dying people that we are ready to treat them with the dignity and trust that they deserve.
Shadiq Al-Hassan.
Thank you, Madam Deputy Speaker. Before entering this place last July as the member for North Somerset, I have been a pharmacist for nearly 20 years. Pharmacists have a unique role to play in our healthcare system, and as the group of health professionals specialising in drug usage and safety, and so that is where I wish to focus my thoughts today, and so offer the House my expertise. Throughout the passage of this bill, we've had a great benefit of learning from a number of international examples. In Australia, we've seen a carefully designed countrywide pharmacy system that has delivered self-administered assisted dying safely and with dignity. The evidence from their experience is greatly reassuring. Even in cases where the drug was not fully ingested, every patient who made use of the service died peacefully and without complications, with not a single complaint yet received from any of the families involved. From Switzerland, we've learned from their decades of practice where they have refined the substances and processes involved to the point where complications are now nearly unheard of. Their approach demonstrates that with care and rigorous regulation, drugs can offer an effective and compassionate route to end one's life. This brings me to new clause 13, introduced by my friend the member for Spen Valley. This clause outlines a comprehensive framework for the oversight and safety of substances involved in assisted dying. As is only right for life-ending drugs, the public expects the highest standards of transparency and standards from manufacture to dispensing. And as someone involved in every facet of pharmacy for the past 20 years, I believe this clause meets all of our expectations. By strengthening safeguards and enhancing the workability of this bill, new clause 13 ensures healthcare professionals can act with clarity and confidence. Amendment 72 is similarly important, and I believe will provide much assurance to those in this place who are uncertain about whether or not they feel they can support this bill. By ensuring that all regulations made by the Secretary of State under new Clause 13 are subject to the draft affirmative procedure, this will ensure this place continues to play a central role, overseeing the safe and effective implementation of this legislation for years to come. And through our collective continued scrutiny, offer the opportunity for many millions of constituents who have contacted us on this issue the chance to continue having their voices heard and their concerns answered.
Harriet Baldwin. Dave.
Thank you very much, Madam Deputy Speaker, and I rise to speak to new clause 14 and amendments 14B and 14A, and I was honoured to follow the speech from the member for Rochdale, but also want to thank the member for Spen Valley for working closely on this issue of banning advertising, because whatever your views are in terms of assisting terminally ill adults to end their lives, and I remain implacably against the potential harms that arise when our society and our imperfect state is given permission to help people kill themselves. I have to acknowledge that there was a majority at second reading in favour of this bill and a majority in terms of closing down debate the last time we had report stage. And so thinking ahead to the possibility that this bill might go on the statute books, I hope everyone participating in this debate will recognise that we should not allow the services of the organisations that will arise to provide this service to advertise on television, online, on posters, on TikTok, on any platform that our constituents may be seeing. And I think we can all imagine a scenario where if this bill passes and the House doesn't agree to new clause 14, that the independent contractors, the not-for-profit firms, perhaps even the NHS itself, will be able to advertise to potential customers, for example, on afternoon television. Can you imagine a situation, Madam Deputy Speaker, you're sitting watching a repeat episode of One Foot in the Grave and an advert runs for a funeral plan company, and then it's followed by an organisation that's offering to provide the services to make it easier for you to have an assisted death. You may think that I am painting a situation that is only hypothetical, but in fact we've seen in Belgium that the government itself is running online adverts featuring young, healthy women at a yoga class talking about how they're worried about Granny's situation and asking if they've considered telling her about the option of assisted dying. So I'm very grateful to the Honourable Lady for tabling her new clause 14. I don't think it's perfect, but she and I had a lot of discussion about the wording, and I do also support the intention behind Amendment A and B to new clause 14, because I think it is important, and we've heard ministers, and I hope they will again today, confirm that encouraging assisted dying under this bill remains a crime under Section 2 of the Suicide Act. However, it does require showing intent to encourage, whereas adverts themselves might be framed so that they're not so intended. So it is right that there's a specific provision on advertising needed in this legislation. I am also concerned about, in the unamended new clause 14, about the scope of some of the exceptions. I'm grateful that the, for example, in subclause 2 doesn't refer to potential service users, but there's nothing that prevents the Secretary of State with the Henry VIII powers from exercising the power to exempt them. So doing so would negate the point of the prohibition. So I'd be grateful if the Minister would confirm that the power will not be exercised to create exceptions for adverts that are targeted at potential service users. And it's absolutely the case that, as the member for Rochdale mentioned, there are a number of advert bans already in existence on the face of legislation. For example, the Cancer Act, the Surrogacy Act and the Tobacco Advertising and Promotion Act. And they are set out clearly on the face of the bill. So I hope this can be resolved. I hope the House today will support at a minimum the new clause 14 proposed by the proposer of the bill. I hope that the House will also support the strengthening amendment, which I endorse. And I hope that ministers will confirm that these powers would never be used to create an exemption to Section 2 of the Suicide Act in order to partially allow encouragement of assisted dying, as I think it would defeat the whole point of the provision.
Alison Hume. Thank you, Madam Deputy Speaker. I rise today to speak in favour of new clause 15, which clarifies that an assisted death would not be classified as an unnatural death and a full coroner's inquest would not normally be required. My constituent in Scarborough and Whitby, Anthony Shackleton, lived with motor neurone disease for 6 long years. As his condition worsened, his options narrowed until there was only one choice that preserved his dignity, autonomy and peace: to travel to Dignitas in Switzerland and end his suffering on his own terms. Louise, as his wife of 25 years and someone who had known him since the age of 18, did what any loving partner would do. She stood by him. She helped him onto that plane. She held his hand through the most difficult decision of their lives. And now, for that act of love, she is under police investigation. Madam Deputy Speaker, that is precisely why we need new clause 15. If the bill is passed, then assisted dying would be a legal, strictly regulated and monitored choice made by the individual concerned. There would be strong... I will give way.
Thank you ever so much to my honourable friend for giving way and recognise the situation of your constituents is awful. But we're here to balance today the choices of people who may not be loved as dearly as him. And our concerns here would be about the fact that many of these killings could be mercy killings, and that if there isn't that recourse to the coroner, then some people may be taking their own lives under coercion and pressure that may never be discovered because it won't be given the full law.
I thank my honourable friend for her intervention. New clause 15 is particularly addresses the role of coroners, and coroners investigate deaths where there's a reasonable suspicion that the deceased has died a violent or natural death, where the cause of death is unknown, or if the deceased died while in custody or state detention. This is not the case with an assisted death. There would already be strong safeguards in place, including multiple layers of oversight and assessment. The process is cautious, thorough and heavily safeguarded. There is no need to investigate an assisted death, as it is not unnatural. In this country, it is still a crime to help someone die peacefully and with dignity, even when they are suffering unbearably from a terminal illness. Even when... I will make progress. Thank you. Even when they are of sound mind, even when it is their deeply considered wish. Anthony wanted a good death. He wanted to die peacefully, with grace, without pain and without profound suffering. He got that in a foreign country, far from home, far from family, because our laws force people like Anthony to make that desperate journey abroad. Madam Deputy Speaker, this is why I support this bill, and in particular new clause 15, as there is no need for coroners to investigate an assisted death.
Would my honourable friend give way?
I will give way.
I thank my honourable friend for giving way. One of my constituents told me of her mother's pain in her last few months of suffering, so painful that she couldn't bear to be touched by my constituent or her brother. Now, both my constituent and her brother are facing post-traumatic stress disorder because of the difficult situation they witnessed while their mum was dying. Does my honourable friend agree with me that if they had helped her to die in the way that this bill allows, that they should not then be subject to a coroner's investigation? It isn't going to help them and it isn't going to help their mother.
I thank my honourable friend for giving way. She makes a powerful case on behalf of her constituent, and this is a compassionate and practical clause. It ensures that the bill not only works for the individual making the choice, but also for the families they leave behind. Let us not turn our backs on people like Anthony and Louise. Let us not make criminals out of the compassionate. The death of a loved one is always difficult. When someone has gone through the legal and safeguarded process of assisted dying, it isn't right that their family should face an unnecessary, potentially lengthy and distressing coroner's investigation. I'm coming to my conclusion. New Clause 15 will protect bereaved families like that of my constituent Anthony, and therefore I urge honourable members to support it.
As the Speaker has already mentioned, for everybody to get in, well, for most people to get in, we need speeches to be shy of 6 minutes and interventions to be short. Gregory Stafford.
Madam Deputy Speaker, and I'm conscious of those comments, and I will try and limit my comments to new Clause 13 and some of the amendments to it. The Royal College of Physicians, the Royal College of Psychiatrists, the Royal College of Pathologists, the Association of Palliative Medicine, the British Geriatric Society, all have said that there are problems with this bill. And I have heard nothing from the mover of the bill, despite trying to intervene on a number of times, as what she has done to ensure that their concerns have been addressed. And this brings us directly, Madam Deputy Speaker, to a fundamental concern, namely the means by which assisted death would be carried out through new Clause 13. The impact assessment to this bill recognises, and I quote, that the safety and efficacy of those substances used for assisted dying is currently difficult to assess. So no safeguards can... yes, I will.
I'm very grateful to my honourable member friend for taking an intervention. Would he agree that the barbiturates which we are considering are indeed conventional agents? They've been used in anaesthesia to cause loss of consciousness and suppression of respiration for generations. These are not novel substances.
Well, I obviously respect the honourable member given his medical background, but as far as I'm aware, they have not yet been used for murdering people, which is what we are going to do here. And that is the simple thing, because it leads me neatly on, Madam Deputy Speaker. Can I just make a little bit of progress, and I will take the intervention. No safeguards can prevent complications on taking medicines, and I'm sure the honourable member who's just intervened on me knows that there are always going to be complications, potentially. And in this case, including regurgitation of the drugs, regaining consciousness, and seizures. Can I just finish this point? In the 27 years the law in Oregon has been in place, data is only available for about 36% of cases. However, within that, 59 incidents of regurgitation are known to have occurred, 9 are known to have regained consciousness, and different drug protocols have been used in those 27 years, but the efficacy and safety of the drugs are unknown, with the time range between ingesting drugs and death ranging from 1 minute to nearly 6 days. The lack of defined protocols for the regulation, supply and administration of life-ending substance is precisely why I've tabled my Amendment C to the member for Spen Valley's new Clause 13.
My honourable friend's right to table the amendment, I certainly support it. And does he agree with me that the MRHA would insist that a barbiturate or any other substance used in medicine is approved for a specific cause, and you can't translate that to a completely different cause? Reason for doing this, and would he further agree with me that the way to deal with this is to have this properly regulated through the MHRA?
Oh, I entirely agree with my honourable friend, and I think some of the amendments made by my honourable friend behind me may address that. Can I just make a little bit progress, but I will give way to him in a moment. My amendment would require the Secretary of State to prohibit the use of medical devices designed to induce death by the administration of gas, such as the Sarco suicide pod, which has been in the press recently. This device bypasses medical oversight entirely and presents an ethical rupture in our current framework. If this bill proceeds without safeguarding against such methods, we risk opening the door to a deeply troubling precedent, one that would erode professional accountability and compromise the integrity of end-of-life care. And I give way.
I thank the honourable member for giving way. I would like to share with the honourable member, Madam Deputy Speaker, my expertise as a pharmacist, that drugs can be used for many indications, and are quite commonly used in unlicensed situations where there would be less evidence to support them than in the situation that we are coming and discussing today with New Clause 13, an idea that is incredibly well researched and practiced and evidenced in multiple countries.
I thank the Honourable Gentleman for his intervention, and I don't disagree with him that drugs are used for different things. That is not the point of the thrust of the argument I'm making. What I am saying, I hope relatively clearly, is that the medicines that the drugs that we are potentially going to use in this situation, where they have been used, we can see that there have been unintended consequences and side effects, and we must make sure that the drugs that we use, if this bill passes, are absolutely effective in what they are intending to carry out, namely the end of life of the individuals. This is my last intervention because I do feel I must make progress.
And the reason that is so important is because it's yet another important safeguard, particularly given that we learn, albeit through analysis from the impact assessment, that much of this goes outsourced to private organisations. Those organisations need to be regulated in precisely the way that he's described.
Well, I thank my right honourable friend for that intervention. He's entirely correct. The Royal College of Physicians has said, and I quote, "Medicines prescribed and administered in assisted dying must be regulated for safety and efficacy for this use." And if it's good enough, and it's the requirement, I think, from the Royal College of Physicians, then it's something that we in this House should take seriously and put on the face of this bill. I will draw my remarks to a close, Madam Deputy Speaker, but I would like to say that I do also show my support for Amendment 99, which I think will require a report on the drug effects before Parliament approves the regulation, and a number of the other amendments which would hopefully remove the wide-ranging Henry VIII powers that this bill currently has. In light of all of this, Madam Deputy Speaker, I remain deeply sceptical that this bill, in its current state, provides the robust, protective and operationally sound framework that such a profound societal change deserves.
Adam Jogi.
Deputy Speaker, I'm grateful to you for calling me to speak this morning and to give me the first opportunity to speak on this most important of issues in this chamber. And as I do, I think of all those who were killed in the horrendous plane crash in India yesterday, and I think of their families, friends and the lives they've left behind. May their collective and individual memories be a blessing. Madam Deputy Speaker, I rise to speak to Amendment 42, tabled in my name and the names of more than 60 colleagues in the majority of parties represented in this House and representing constituencies in all 4 nations of our United Kingdom. Amendment 42 would remove the automatic commencement of the bill's provisions taking effect in England. This is a safeguard, good and proper. In the bill as it stands, the entire assisted dying process has to commence automatically in England 4 years after the Act is passed. And notwithstanding some of the comments we've heard earlier on, that will be regardless of how far along the plans and preparations are, or the manufacturing and supply of the drugs used to end the life of anyone who chooses this step, the identification and training of those on the panel, the impact on the National Health Service in England and in Wales, the budgets and the rest. Colleagues will know that the first draft of this bill, this process was due to commence, 2 years after any such act was passed into law. I welcome the fact that my honourable friend, the lady for Spen Valley, amended the first date of this bill from 2 years to 4. It was a genuinely welcome acknowledgement that such a serious and consequential change to every aspect of our country, from our healthcare system to our legal system, should not, must not and cannot be rushed. And therein lies the basis of my amendment. If this change is going to happen, let's do it properly. Let's not impose a time frame that puts us in a bind and means we are driven by timing over purpose and the pressure that comes with a ticking clock, rather than by doing it properly. People living in Newcastle and Madam Speaker, to York Outer, from Buckingham and Bletchley to Pembrokeshire, are counting on us parliamentarians, both of us, who are concerned about assisted dying and those who are in passionate support of it. This bill has won every single vote on the floor of the House, apart from on this issue at committee. Our people are counting on us to make sure that if this bill passes, that it is a success, that it will be consistent, and most importantly, that it will be safe. If this bill passes, it will introduce assisted dying in the biggest jurisdiction yet by population. These are uncharted waters, Madam Deputy Speaker. It will not be like anything else. The last thing we should be doing is rushing this process. At committee stage, the Honourable Lady from Richmond Park, who I thought spoke excellently earlier on, tabled an amendment which passed and successfully removed the automatic commencement deadline for Wales. Her amendment made provisions that assisted dying could only be rolled out once Welsh ministers deemed everything was ready for a safe rollout. The committee voted by a majority to give this extra safeguard to the people of Wales. Madam Deputy Speaker, if it was good enough for the people of Wales at committee stage, it's good enough for the people of England today. In other words, we face a situation where assisted dying may proceed in England months or even years before Wales. The provisions and the systems may look different. The process of organising the English system to meet the arbitrary deadline of 4 years would almost certainly lead to rushed decision-making. Now, my honourable friend, the Honourable Lady from Spen Valley, has sought to remedy this disparity. But her solution isn't to extend the safeguard that members of the Bill Committee, may I say members that she appointed, to my constituents in England. No, Madam Deputy Speaker, the remedy is to allow for auto-commencement to happen in Wales as well, removing a safeguard that the Bill Committee voted for. The answer to this is not two fast-tracked rollouts of assisted dying in both England and Wales, potentially putting the lives of some of the most vulnerable at even greater risk due to rushed or not full thought through decisions. I haven't been on these benches very long, Madam Deputy Speaker, but arguing for the auto-commencement of legislation generally is, in the kindest interpretation, unusual. For legislation of this magnitude, it is, I'm afraid to say, reckless.
Hear, hear.
And reinstating an auto rollout in Wales, when the Bill Committee explicitly voted against it, borders on the undemocratic. Members, I will give way to my honourable friend.
Visit the Isle of Man and met the sponsor of their bill. It took 3 years to get to this point. The House of Keys has 24 members, and the sponsor of the bill thinks it will take at least 5 years to implement it in the Isle of Man, a much smaller jurisdiction.
Well, my honourable friend makes a very good point. But I'll give one to the other side, then I will continue with my remarks.
Fast becoming one of my favourites on the benches opposite, amongst many competitors, by the way. But the point that he makes is fundamental, because if we're going to do this right, we have to do it thoroughly and by independent analysis. Had the Honourable Lady had the kind of pre-legislative scrutiny and thorough analysis before the bill, we may have ironed these matters out in the first place.
I thank the Honourable Gentleman for his intervention. It teaches me not to take them, and thanks for the thanks for helping the street cred this morning. But, Madam Deputy Speaker, he raises an important point. Now, members of this House have been told that this bill, because it is this bill that we're voting on, Madam Deputy Speaker, today, not the principle, was rigorously tested and refined in committee. However, we are now seeing efforts to undermine the decisions of that same committee. Amendments 94 and 95 serve the singular purpose of undoing amendments introduced at the committee stage to improve this bill, to make it a safer, more conventional piece of legislation. But the implications of these amendments go beyond just this. They also challenge the basic tenets of our democracy. One of the key roles at the heart of our democratic system is the role of the or a Minister of the Crown. It's our ministers who prepare the groundwork for legislation to be enacted successfully, and these amendments would completely do away with this core ministerial function. They would see the responsibility for ensuring the rollout of assisted dying in Wales, the power we, the people, entrust to our ministers in a democracy taken away from them. Conscious of your cough, Madam Deputy Speaker, I shall quickly move towards the end of my remarks, so I have taken half of them out already. Ministers, in my view, Madam Deputy Speaker, should be able to lead the rollout of assisted dying in Wales just as they should in England. It is ministers, not the bill supporters, who will be responsible for delivering these seismic changes to our health and legal systems. It is only right that they decide when the provisions become law. Amendment 42 would put England back on an even footing with Wales. Getting this right is literally, Madam Deputy Speaker, a matter of life and death. It makes sense to avoid any possible pressure on decision-making and the decision-makers. It makes sense to, at the very least, allow government ministers to enact legislation with the usual constitutional powers. One death because of a rushed decision would be one too many and should give us all food for thought. I don't want it on my conscience, Madam Deputy Speaker, that our collective sticking to an arbitrary deadline led to a death or deaths that may otherwise not have taken place. We must recognise that we can prevent any such situation, and we can prevent that with our vote today. To do so, we must remove the deadline for automatic commencement in England, and we must uphold it in Wales. And I urge members to support my Amendment 42 and to vote against Amendments 94 and 95. Thank you.
Yeah. Tom Gordon.
Thank you, Madam Speaker. To Amendment 3 in my name. which is the exact opposite for the member for Newcastle under Lyme. In fact, it would see the commencement period be reduced down from 4 years to 3. This is something, as a member of the Bill Committee, when we had that initial conversation about increasing the commencement period from 2 years to 4, I was the only person to speak against it and pushed it to a vote. What frustrates me about the situation that we're now in is that, for in effect, we are acknowledging that the reason that we're here, that we're debating this bill, is that the status quo is not acceptable, that people are pushed to taking decisions that they shouldn't be, having to go to foreign countries to have that opportunity overseas. And I think those of us who support this bill are broadly in agreement on those principles. What frustrates me about this 4-year period is a number of things, principally that the people who are in office today, the government of the day, wouldn't necessarily be here to be implementing it. And I'm really hesitant about supporting a bill that we wouldn't know who would be then seeing through those details. So the amendment reducing that threshold back down to 3 years would still be more than most jurisdictions around the world. There have been countries which have implemented assisted dying legislation after as short as 6 months, 12 months and 18 months, so 3 years would still be a substantial increase on other countries. We're not innovators, we're not leaders in this field. There is no reason that we can't take best practice and learn and speak to colleagues around the world. I believe this bill does have the strongest safeguards of any, which is why I think an implementation period of 3 years would more than meet the requirements.
Tony Vaughan.
Thank you, Madam Deputy Speaker. I want to put on record my sincere thanks to the Honourable Member for Spen Valley for the way she's approached this bill throughout. Her willingness to listen to concerns from across the House has been evident, not least in her clause brought forward in the names of members for Reigate and West Worcestershire. It's a testament to how we can work together on these deeply sensitive issues. I rise today to speak in favour of NC14 but against NC14B. I want to begin by saying that I absolutely understand the intent behind this amendment in the name of the member for Rochdale. Nobody in this House wants to see voluntary assisted dying services being advertised in a way that is insensitive, inappropriate or exploitative. We all want to protect individuals, particularly those who may be vulnerable or more easily influenced, and I fully share that concern. But while I respect the principle behind the amendment, I do not believe it offers the right solution. The underlying clause NC14 rightly prohibits advertising voluntary assisted dying services to the public, while giving ministers tightly defined powers to create appropriate exceptions through regulations. Now that's important because in a healthcare system as complex as ours, we must be able to draw the line between unethical promotion and responsible professional communication. The original clause, in my view, gets the balance right. What the amendment does, NC14B does, is two things, which in my view are both problematic. First, it tries to define on the face of the bill a narrow list of exceptions to the advertising ban, just two, replying to individual requests and professional communications that patients are unlikely to see. But as we've heard from legal experts, and I share this view, that writing into primary legislation removes essential flexibility, which may even hamper implementation. Ministers would not be able to respond to future developments or clarify borderline scenarios without coming back to this House with further primary legislation. It could also limit the ability of future ministers to clarify how the system should work in real-world and evolving situations. Good regulation should be responsive and proportionate and not fixed to a point in time. Second, this amendment attempts to limit the scope of further future this amendment attempts to limit the scope of future regulation by barring any changes to the Suicide Act 1961. But that is already covered. NC14 already prevents changes to this bill, so the additional clause is not only duplicative, it closes off any future clarity that might be needed in the Suicide Act, such as to ensure offences around coercion or fraudulent practice are properly dealt with. So, in short, this amendment does not, in my view, add clarity, it risks confusion. It doesn't strengthen the advertising ban, it introduces constraints that could make this provision harder to enforce and evolve in practice. I will give way.
I thank you for giving way, given the time constraints. There's a key question here, it's quite simple on this point. Does advertisement include a leaflet on a GP's surgery table or on the door going into a GP, because to me it seems very unclear what is information and what is advertisement here.
Well, that will have to be worked out. I don't have the answer to that to my fingertips, and it may be that others do. But further to what I said, I was pleased to hear the Honourable Member for Spen Valley say earlier in the Chamber that she is open to working with the Honourable Member for Rochdale and others in the Lords to find a workable way forward on all of these issues, including that one. So I hope he's able to take up her up on that offer, because this is obviously an area where constructive cross-party work could ensure that the strong safeguards are achieved without unintended consequences. For now, I'm essentially done now. For now, I'll urge members to reject this amendment in its current form, not because we oppose its aims, but because we can and must find a better way to achieve it.
John Glenn.
Thank you, Madam Deputy Speaker, and I'm grateful for the first opportunity to contribute on this bill. It wouldn't be appropriate for me to dilate on my profound anxieties and concerns about this. But I do approach the amendments that I rise to move today in the spirit of constructive engagement with the bill and what has come before it. So I rise to move amendments 82, 83, 84, 85 and 86. And these linked amendments would strengthen the panel by giving it some of the features of the High Court safeguard, which has regrettably been removed. And we've heard from the bill's sponsor that the panel will now be stronger because it includes a broader range of expertise. And of course, the argument against that is that the High Court was a stronger safeguard because it has the powers of a court and the independence of a judiciary. But my amendments would mean that we don't have to choose between the two. The panel is now part of the bill, but we can have a better panel if we give it some of the features of a High Court, namely the court's independence, the calibre of its judges, and its powers as a court. Amendment 82 would require all panel members to be appointed by the Judicial Appointments Commission, which nominates judges in England and Wales. Currently, the selection of panel members is wholly down to the Voluntary Assisted Dying Commissioner, and Schedule 2 says the Commissioner must make appointments to a list of persons eligible to sit as members of panels. Now, I have absolutely no doubt, Madam Deputy Speaker, that the Commissioner will be someone of great integrity and experience. But he or she will certainly be a strong advocate of assisted dying, and so will those who put themselves forward for the panels. Now, that may create an impression that the VAD Commission is a self-selecting group with a particular set of institutional views. Now, I believe that if this system is to command public confidence, then the appointments would be best administered by some external body, and the Judicial Appointments Commission is the obvious choice. We, in this country, I hope, trust the judiciary, partly because we know that they represent no set of opinions. Just a commitment I'd be very happy to give way to my neighbour and honourable.
I'm very grateful. I'm grateful to him for his amendments, and of course he's absolutely right that this country trusts the judges, and that is why this House was so enthusiastic for the High Court stage of the original bill that was introduced. And does he agree with me that reintroducing a proper judicial scrutiny at this stage would then revert the bill back to something that the House voted for at second reading?
Well, it won't surprise him to know that I do agree wholeheartedly with him, and I do recognise that that was a major reason that many colleagues gave at earlier points in the discussions and deliberations. I'd be very happy to give way to the Honourable Lady.
And I thank him for his constructive engagement, but would he agree that he didn't vote for the bill with the inclusion of a High Court judge, and now he's trying to reintroduce a High Court judge? Is there a version of the bill that he would vote for with some sort of judicial oversight other than a commissioner, which is a judge or a retired judge, a deputy commissioner, a judge or a retired judge, and someone on the panel who is a legal expert?
I've been very clear. I'm approaching my contribution today with these amendments in a very constructive way to try and bring together the will that she has expressed, but also recognise, I believe, the meaningful dilution in the authority of this process and what can reasonably be amended to invigorate it along the principles that was intended, I think, at the outset. If I just revert now to the point I was making about the judiciary, I mean, they just have a commitment to uphold the law. And I think that that should be the standards that we should be looking for when it comes to matters of life and death. The Judicial Appointments Commission already conducts appointments for all tribunals, including lay members of tribunals. The government's impact assessment compared the panel to the Mental Health Tribunal. But all appointments to the Mental Health Tribunal, including the non-legal members, are done by the Judicial Appointments Commission. So this would not be a novel function for them. Now, let me move on to Amendment 85. This ensures that all the members of the panel have to take the judicial oath if they have not already. If other amendments pass, this would only be necessary for the non-legal members. It is crucial for public confidence that the judicial oath is taken. Amendments 83 and 84 seek to preserve an important element of the bill as originally presented to the House. They ensure that the most senior decision-making figure, the chair of the panel, will be a High Court judge, with all the experience, responsibility and professionalism that this implies. Under these amendments, all High Court judges will be automatically eligible. They must be either currently or serving or at least below retirement age, and it must be judge of the highest authority, not a deputy judge. Members of this House and the public, for that matter, were originally told that this would be a safe bill precisely because it would have a High Court judge, and that was a persuasive promise, and I think there is a way to honour it even in the new version of the bill. I would also just like to briefly mention the retirement age, if I could, because it is important. It used to be 70, it is now, judges can continue to 75. But with the panel, there is no age limit. Now, if we're saying that an 80-year-old retired judge is still with it and is able to decide on matters of life and death on these panels, then why are they saying that they are too old to help clear not too old to help clear the backlog of criminal cases? This seems a meaningful anomaly. So, Madam Deputy Speaker, in the interest of time, I think I've made very clear the purpose of these amendments. I bring them to the House today in the spirit of trying to bring and strengthen the bill back to where it was intended and meet the expectations of so many who supported it at an earlier point.
Sir Alison Gardner.
I rise to support a number of new clause and amendments to this bill. The common thread to all the amendments is to address some of the gaps in terms of safeguards and oversight the current form of the bill lacks. Should this bill pass, I want to at least ensure that it is improved and has better protections than it currently has and removes some of the risks it contains. New Clause 4 requires monitoring by the Chief Medical Officer rather than depending solely on the Assisted Dying Commissioner. Alongside the requirement for a High Court judge, oversight by the CMO was removed in the committee stage. This means the Commissioner would essentially mark their own homework. NC4 returns this safeguard and independent oversight, highly sensible given the significant concerns expressed by this bill from many experts and organisations, often neutral on the principle but concerned about this bill. This includes, as previously mentioned, the Royal College of Psychiatrists, the Association of Palliative Medicine, British Geriatric Society, the Royal College of Physicians, and many experts, such as Professor James Monckton-Smith, a leading criminologist, Baroness Finlay, Parliament's leading expert on palliative care, Professor James Monckton, and Sir David Haslam, former head of the British Medical Association and of NICE, my previous employer, and many more. All have expressed concerns, even when neutral on the principle of the adequacy of this bill. Hence, NC4, which requires an annual report to include information on the application of the Act in relation to persons who have protected characteristics and other descriptions of persons specified in regulations made by the Secretary of State, and I fervently hope includes domestic violence victims. Amendment 13 very sensibly adds the requirement that the Commissioner appointment is not the sole remit of whoever is the Prime Minister at that time, by requiring the consent of the Health and Social Care Select Committee. This provides a safeguard against ideological or politically motivated appointments. I would be very quizzical as to why anyone would prevent this. Amendment 15 addresses the significant concerns of the involvement of private for-profit providers of assisted dying. There are concerns of gaming of the system when there is a commercial relationship between providers, meaning the relationship of the coordinating doctor and independent doctor risks being compromised. Likewise, existence of such providers does not allay concerns of doctor shopping as raised in the previous debate. Hence, Amendment 15 will require private providers to be transparent and provide reports on service numbers, costs and revenue. In previous debates and in the public discourse, I found it very disconcerting that in response to legitimate concerns, all we have been offered, as we have seen today, are some promised unspecified future regulations that will fix the gap. Yes,
I thank the honourable member. She's making very powerful points. Does she also share my concern that most of these discussions that we're having today have been hashed out at committee stage, and now we're being told we leave them to the Lords because we can't even fix them here? That is a really flawed process.
I entirely agree with my honourable friend. To expect MPs to improve this bill without clarity as to what these regulations are or will be, how the service will be delivered, and without rigorous regulatory oversight is fundamentally wrong. In light of this, the fact that implementation of this bill will be automatic in 2029, a general election year incidentally, is not realistic when reflecting on the many areas where we still lack detail. Hence, I am supporting Amendment 42 proposed by my neighbour and honourable friend of Newcastle under Lyme, which allows the Secretary of State to determine the appropriate date for the bill to be implemented. This would allow time for the NHS to be fit for purpose, palliative care to be strengthened, and adequate regulations to be drafted and scrutinised by Parliament without being rushed. Similarly, but fundamentally to the society we live in and for our most dear institution, Amendment 12 protects the fundamental status of the NHS. The current bill provides us, before us provides Henry VIII powers to amend the NHS Act 2006 without limit, which could include a specification of charges. If, as Labour MPs, we are committed to protecting the NHS being free at the point of care, then Amendment 12 is vital. This amendment will require any changes to the NHS 2006 Act to be made via an Act of Parliament. The future is uncertain. We must build in safeguards in the face of a bill that fundamentally alters the fabric of our society. There are many others I will mention. Briefly, Amendment 27 requires the licensing of drugs used for assisted dying by the MHRA. Research has shown that painful and protracted deaths via assisted dying drugs are not uncommon, with deaths ranging from 3 minutes to 137 hours, nearly a week, with up to 8 hours to lose consciousness and serious side effects, disproportionately affecting younger people. Amendment 27 will help ensure the safety and efficacy of these substances. I will close, Madam Deputy Speaker, with quoting Sir David Haslam in response to some of the individual stories used on both sides of the debate and how we balance these with the good of society. As you know, NICE has to make the difficult decision to approve or not approve medications and treatments based on a cost and clinical effectiveness model. They are experienced in weighing up societal good, I'll be quick, Madam Deputy Speaker, versus the need and wishes of individuals. Sir David states, from individual perspectives, assisted dying appears a logical development, but from the perspective of society, it is likely to have profoundly different impact, with a legion of unintended consequences. Once we blur the boundaries, there is no going back, and the elasticity with how assisted dying laws have been applied in other countries shall serve as a warning that such legislation is inherently unstable. So in closing, Madam Deputy Speaker, even if we apply all the safeguarding amendments put forward, this bill will still not be fit for purpose. The Renters' Rights Bill contains 191 pages. The End of Life Bill consists of just 43. But should it pass, let us at least try to ensure that we have inserted some level of safeguarding and oversight. As such, no matter how you stand on principle, I urge all honourable members to support the new clause and amendments I have addressed and have not had time to address, particularly NC4, Amendments 12, 15, 27 and 42. Thank you.
Paul Kohler.
Thank you, Madam Deputy Speaker. Let me begin by laying my cards on the table. I am, of course, a Liberal and have always supported the right of individuals to freely choose when they want to end their life. I have no religious or philosophical objection to assisted dying, and when the debate on this bill began, assumed I would vote in favour of it. However, as the debate in this chamber on the second reading progressed, and in particular as a result of the compelling speech of the member for Vauxhall and Camberwell Green, the City of Durham, and in particular the Mother of the House, the member for Hackney North and Stoke Newington, I came to the reluctant decision the state of palliative care in this country and the safeguards against coercion in all its forms were not sufficient to vote in favour of this bill. Despite the changes at committee stage, my mind has not changed. I will again be voting against the bill. However, can I equally be clear, Amendments 103 and 104 in my name, and to which I will now speak, are not wrecking amendments, but critical to ensure there's proper parliamentary scrutiny if this bill becomes law. Yes, I will.
I thank the honourable member for giving way. The issue of palliative care has been raised across this House, and we've been repeatedly told that this is not an either-or choice. But does the member agree with me that without world-class palliative care, that will force some patients down the assisted dying route where otherwise they would have chosen better care?
I agree entirely with the honourable member. It would not be a free choice if we make that choice now with the standard palliative
Would
care.
the honourable member give way?
This is the last one, I will.
Thank you very much. I thank the honourable member for giving way, and I share with him concerns about the level and the quality of palliative care in this country. However, I do not agree that giving people the choice to end their life if they are terminally ill and have a diagnosis that they are going to die shortly in any way undermines our ability as a House to insist on an improvement in palliative care. What's more, statistics from other jurisdictions show that once given that choice, people often turn to palliative care.
I thank the honourable member for intervention. All I would say is giving people a choice when they look on the internet and see how awful their death might be because the shocking state of palliative care is not a free choice. This is an extraordinary bill. It has 45 clauses and 38 regulation-making powers, of which 5 are Henry VIII powers, in other words, powers to modify primary legislation. As Ruth Fox of the non-partisan Hansard Society, who are absolutely neutral on assisted dying, made clear there's lots of powers in this bill conferred on ministers. Why is this a problem? Well, Lord Hermer, KC, the Attorney General, in his Bingham lecture last year, puts the point as follows. Henry VIII clauses upset the proper balance between Parliament and the Executive. This not only strikes at the rule of law, but also at the cardinal principle of accessibility and legal certainty. I'm afraid this bill is an example of such excessive reliance. There's a major problem because in large parts the safeguards are left to be decided by regulations. What level of qualifications and training will the doctors need to have? How will mental capacity be assessed? Who can be a proxy? What happens if the self-administration of drugs goes wrong? The person suffers complications but does not die. When pressed on the key safeguards and key issues, supporters of the bill say that they are problems which will be approved later. The same goes for how this will actually be delivered. Will it be the NHS? And if so, how? Will providers be commissioned? And if so, how? By whom? And on what terms? Will for-profit providers be allowed? All of those questions are unanswered by the bill that was introduced in the House. I'd hoped that they could be answered in committee, but they were not. Instead, we got even more reliance on delegated powers. Firstly, it means that MPs cannot make a judgment about assisted dying, how assisted dying will actually work in practice. Take training, for example. MPs might assume that the training provided will be a robust 2-week course on assessing coercive control. There's no such requirement in the bill. And indeed, the impact assessment suggests it would be a short course. Secondly, regulations cannot override the statute. They are ultimately bound by it. So whilst it might be reassuring that a code of practice will have to be issued, taking into account how depression can impair a person's decision-making, it does not change the fact that impaired judgment does not mean that someone lacks capacity, as the Royal College of Psychiatrists have recently reminded us. Thirdly, leaving all those matters to be considered by guidance regulations places them outside the democratic control of MPs. With very limited exceptions, they will not get a vote on those that will have no input, directly or indirectly, in formulating them. The case for the defence might be that reliance on that is inevitable for a bill of this complexity. The experience of other common law jurisdictions suggests this is not the case. In Victoria, the first Australian state to legalise assisted dying, there are only 20 pages of regulations, as they have included much more within the Act, which is necessarily longer than the bill for us today. That is a good thing, as it means more parliamentary scrutiny. I hope you understand why it was not possible for the member for Spen Valley to draft a bill as detailed as the Australian one before second reading, but I'd hope that with the help of government resources, those gaps would be filled during the course of the committee and report. Sadly, this is not the case. I had much more to speak about, but heeding the Deputy Speaker's cough, there, all I'd say is, so in finishing, can I just say that I might clear at the outset I will be voting against this bill, but even if you disagree with me, please vote for both my amendments. Thank you.
Thank you, Madam Deputy Speaker. I want to begin by thanking my honourable friend for Spen Valley, who has exemplified the integrity and transparency that we need in public service. Today, I wish to speak to Amendments 82, 83, 84, 85 and 86, as mentioned earlier by the Honourable Member for Salisbury. As a former lawyer, these amendments do concern me. In committee, the Minister for Courts was clear that the panel's decisions will be subject to public law principles. This will include procedural propriety and absence of bias, including the appearance of bias. My concern is that this panel is deliberately designed to be inquisitorial. It's intended to collect information. It's not meant to be adversarial like a court. Requiring a judicial oath... No, I'm going to make some progress. Requiring a judicial oath would be inappropriate because this panel is not performing a judicial function. It's a specialist administrative panel whose first priority must be focused on safeguarding and the review of evidence. Disqualifying retired and deputy judges... No, I'm going to make some progress and expand on my point. So, disqualifying retired and deputy judges would only shrink the pool of experienced candidates. And I do not believe these changes would make the process safer, more effective or better. Instead, it would make it more difficult to appoint experts to allow the panel to function as the necessary safeguard that it needs to do. Finally, I return to the most important aspect of this bill: those who are affected directly. Opponents present hypotheticals, but I've heard real stories from my constituents who support this bill. One constituent told me about her husband who died of metastatic prostate cancer. He wanted to die at home. Despite the efforts of a dedicated palliative care team, his final month was marked by excruciating pain. Our constituents deserve better. They deserve the choice to say goodbye in peace, surrounded by loved ones without unbearable pain. For me, this debate is about whether the status quo is acceptable. After hearing these stories, listening to lawyers and doctors, it's clear that it is not. And if we vote in favour of it, it must be a bill that our constituents will expect to come forward and be brought into law quickly. So I'm therefore opposing Amendment 42. Madam Deputy Speaker, the British public overwhelmingly support this bill. They are looking to this House for courage and leadership, and that is why I will vote for this bill with the amendments that strengthen it. Let's bring dignity, peace and choice to those facing the end of their lives in difficulty and pain.
Ben Spencer.
Thank you, Madam Deputy Speaker. Before I come to the substantive part of my speech, I'd just like to pick up on some of the comments from the member from North Warwickshire and Bedfordshire. Bedworth. I've signed the amendments from the member of Salisbury because I support them, because I think the panel does need strengthening. It's not the case that courts have to be adversarial. Tribunals are set up to be inquisitive. In fact, the Mental Health Tribunal is set up to be inquisitive, and that's why at committee stage I tabled amendments to this bill to use a tribunal panel as the mechanism in terms of scrutinising decision making. It's been a real pleasure to listen to this debate this morning, because particularly on the areas relating to the prohibition of advertising, because the debate started to move to focus on issues around suicide promotion and suicide prevention. And this is something, the substance of which I've been quite concerned from the beginning that hasn't been part of what we've been talking about. I think it's a real blind spot within this bill, the interaction with duties to prevent suicide, be that doctors' duties under Article 2 of the Convention, be that the NHS's duties around prevention of suicide, clinical duties around it, and the operation of the Mental Health Act with this bill. And I think the reason why it hasn't been focused on up until now is because of the framing of the bill as the assisted dying bill, as opposed to a assisted suicide bill. And in a way, I also blame myself in part for this, because I started calling this physician-assisted suicide. I started using the term assisted dying because it was in common parlance and what everyone was using. But I think the problem is that it frames it as something else. It frames it as reducing the dying process, as opposed to what it is, which is an act which is to end somebody's life. It's why in Amendments to the Suicide Act, and it's why I've tabled amendments similar in terms of how this is conceptualised. Of course.
I thank the honourable member for giving way. I'd just like to take issue with some of the language being used. We've heard the word murder, killing, suicide. 23 years ago next week, my husband died of terminal cancer. He was in extreme pain and was given morphine to relieve his pain. And as the pain got worse, he was given more morphine so that he could die gently and not in complete agony. This is about helping people die in a civilised way and helping their families not go through a horrendous experience of watching a loved one die in agony. And to call it murder and killing is so wrong. And I think we have a duty to mind our language about this bill. It's about helping people die quickly and with dignity. It is assisted dying.
So,
before Dr. Spencer resumes, it has been a very well-tempered debate. Let's keep it so. We know our constituents are watching. Dr. Spencer.
So I thank you for your intervention. And of course, there are situations in which a decision to end one's life is perfectly understandable, indeed rational. I spent my career looking after people who, many of whom present to me and to medical services with thoughts about wanting to end one's life. Many of them have mental illness. Some have had terminal illness. The fundamental problem with this bill is that it turns a complete blind spot to these people who are highly, highly vulnerable. It is absolutely scandalous that we have got to this point and we're still having this debate around the core concepts, which is why this bill should have been dealt with properly from the start with a Royal Commission or a review, so that we don't have this situation where at report stage we are still debating core principles. This is why I have tried over the past months to table amendments which I thought would help it get to a point where we ensure that the most vulnerable are protected if it becomes law. My amendments 19 and 20 work to edit the code of practice to this bill to make sure that there is clear guidance with regards to doctors' duties, suicide prevention, Article 2, protection of human life, the interaction with the Mental Health Act, because the bill is currently blind on what you do with people detained in hospital or you do with patients presenting with suicidal thoughts. I have great concerns that there will be many people who are quite unwell psychologically who will start presenting to services seeking, inverted commas, an assisted death rather than presenting with suicidal ideation. And the guidance on this, of course I will.
Won't be the only person in this place who's lost someone they love to suicide. And as I listen to what the Royal College of Psychiatrists, who are not in principle opposed to this bill, and things they've said recently, the penny drops for many of us that for many people given a terminal diagnosis, they also have mental health issues, which of course come with them. How does he think we distinguish between a person who chooses to end their own life because of a mental health issue, because of despair, because they have a terminal illness, and somebody who wants to end their life because of despair, because of something else? Doesn't this blur our approach to the important sanctity of life and preventing suicide in every circumstance?
So I thank him for his intervention. I think, of course, these are going to be very difficult things to disentangle. I mean, he would say, well, you would say this, won't you, Ben? But of course, you know, you get in front of a psychiatrist, you get in front of a clinical nurse specialist who's working in psychiatry. This is what psychiatry does. This is what it's about, which is why, again, early amendments I put down, some amendments are to ensure you get in front of a psychiatrist as part of this process. To ensure this blind politics, apologies for speak, I'll finish up now. So my amendments will make sure that the code of practice clarifies this interaction with services. I think I'm pushing it. I tried to intervene on the member for Spen Valley earlier to try and ask her this question, what she thinks about this. She's very welcome to intervene on me now if she's got further points to add. Otherwise, I'll ask the Minister if he, in his winding up, can address these particular points. Thank you.
Over.
Thank you, Madam Deputy Speaker. And I rise to speak to Amendment 27, which would require the doses and types of lethal drugs to be properly licensed by the MHRA. But, Madam Deputy Speaker, it's important to place on record that I do not think that this bill is safe, and it does not provide adequate safeguards, and most importantly, it will deepen and exacerbate inequalities. And on that point, I know I speak for tens of thousands of disabled people who rightly say we need assistance to live and not die. Throughout the passage of this bill, members from across the House have received many letters and briefings from leading experts, including this week a letter from over 1,000 doctors from across all areas of medical practice, expressing the clear view that the bill does not provide answers to how we improve management of end of people's lives. They made the point that the drugs which are expected to be used in assisted deaths should undergo rigorous testing and approval, as would be required by any other prescribed medication. Those requirements are missing from this bill. Indeed, there is nothing in the bill requiring lethal drugs to be regulated by the Medicines and Healthcare Regulatory Authority. And this is contrary, Madam Deputy Speaker, to good medical practice. Many of us will have heard that in Oregon, complications of drugs used for assisted dying occurred in around 7% of deaths and included vomiting, seizures and prolonged deaths of up to 137 hours. Where is the requirement in this bill to inform patients about how these risks, including prolonged dying, might be managed? Where is the plan to identify the most acceptable medications? Madam Deputy Speaker, I want to urge members to, if they have not already done so, to consider this letter signed by many leading experts. As if we do not listen to them, the very people who would have to implement this bill, who will we listen to? I would just like to make one further point, that it is clear that the bill does not protect vulnerable patients from coercion. I'm not taking any interventions. In 2021, the UN human rights experts raised concerns that even when restricted to those with terminal illness, disabled and older people may feel subtly pressurised to end their lives due to social attitudes and lack of appropriate services and support. Now, I know across the House, we know the support for disabled and older people is inadequate. We know that disabled people continue to face disproportionate levels of poverty, isolation and hardship. And until that changes, I urge every member to think and not vote for this bill.
Thank you, Madam Deputy Speaker. I rise to speak in support of new clauses 13, 14 and 15 tabled by my honourable friend, the member for Spen Valley, to support Amendments 94 and 95 and to oppose Amendment 42. And I'd like to pay tribute to the compassionate leadership and immense hard work of the honourable member for Spen Valley and also to the very thoughtful and very hard work done by members of all views who participated in the Bill Committee, those who've worked behind the scenes to scrutinise this and to contribute to the debate. I'd also like to thank all the constituents who've been in touch with all of us, and I'm sure, like me, you've all reflected so carefully on the contributions made by constituents and taken them into account. It is clear, though, that the status quo is not acceptable, and that is why it's right that we have this legislation before us, and why it's right that we are scrutinising it so carefully and looking at it in such immense detail. Turning to new clause 13 regarding the regulation of substances for use in assisted dying, they obviously have to be properly regulated, although it is equally obvious that they can't be subject to conventional clinical trials in the same way as other medicines, and that's why the proposal about making this all go through the MHRA isn't appropriate. But the regulations set out, provided for in NC 13, will ensure that this critical part of the process is carried out with the highest possible level of scrutiny and harm prevention. It's essential that there's transparency and assurance of the process from manufacture all the way through to administration, and that is what NC 13 does. But not everybody. Briefly.
I thank the Honourable Lady for giving way. I'm just interested in what she is talking about in terms of the safety of these drugs, and ask her whether there is any adverse event data existing globally to quantify how much harm and suffering could be caused while inducing that dying process.
Raising this issue, which gives me the opportunity to speak about the very detailed evidence given by my constituent, Emeritus Professor Sam Ahmedzai, who I spoke with at length yesterday about precisely this detail, and I have reviewed a number of tables of data about this. There are side effects of any substance, but the reality is that the comments made in this chamber today have indicated that these substances are being held to a far higher standard than substances routinely used in palliative care. And so we have to recognise that, in fact, in assisted dying, the substances that are talked about, there is a huge amount of evidence about the efficacy of those substances. There's a huge amount of published, peer-reviewed evidence about the effectiveness of those substances. And the reality is that people like my constituent, Professor Ahmedzai, who has 40 years' experience as a global expert in this area, point out that we know how to assist people to have a peaceful, compassionate death effectively. And this is what this is about. It's about people who are terminally ill, helping them to die with dignity, to face those final moments with the support and the love and the care of their family around them, to face them not in agony, but in whatever degree of peace is possible when you are facing death. Turning briefly to Amendment NC 14 relating to advertising, this, as the Honourable Member for West Worcestershire spoke about, this has been developed in consultation as a result of concerns raised by opponents to the bill to try to ensure that crucial thing that assisted dying is not an advertised service. There's a crucial distinction between advertising and information. And so this clause ensures that assisted dying remains a careful clinical process and not something that would be promoted commercially. It's a balanced cross-party safeguard supported by people from all sides of this debate. I'm very short of time. I think I had better continue. Turning to clause NC 15 in relation to the role of a coroner. If this bill is passed, assisted dying would be a very strictly regulated process. The choice of an individual, not a death caused at the hands of others, but by the individual themselves. As Anise Esmail has pointed out, this would be the most scrutinised type of death at all in the country, and therefore it makes no sense to require another legal process at the end of that when there have already been multiple layers of scrutiny before the death. I'm so sorry, but we are very short of time. So this is a compassionate and practical clause. There are strong safeguards already in place. It would go against the spirit of the compassion that should be driving all of us to require a coroner's inquest. And I'll briefly pass to Amendment 42 from the Honourable Member from Newcastle under Lyme, which would remove the backstop commencement, essentially leave it in the hands of the Secretary of State as to when it or if this comes into effect. This would go against the will of the House. If the House passes this bill, It is perfectly reasonable and perfectly workable within the next 4 years for the detail of it to be worked out. We've already doubled the length of time allowed for that to happen. This is effectively a wrecking amendment that seeks to kick the bill into the that would be its effect. So to conclude, Madam Deputy Speaker, I want to briefly address the misconception that seems to have informed some of the comments that I've heard in the debate today, i.e. that the assumption that families would be wanting to pressure family members to die quicker. My mum is a social worker. She's a specialist palliative care social worker. She's told me in all her years of practice she's never experienced that happening. It's the other way round. Family members. Dying people. I'm sorry, I'm concluding. We're each speaking from our own experience and from the heart. The evidence is that it is dying people who...
It is made it clear she's not taking interventions at this time. Continue.
It is dying people themselves, facing the end of life, who wish to have the choice. Only small numbers of them will take this choice up, but it is crucial, humane, compassionate for us to offer them that choice. Assisted dying is complementary to palliative care. It's not contradictory. And this bill has been through a huge amount of scrutiny, far more than any other bill this session. Therefore, I deeply hope that the House will pass this compassionate, humane and clearly drafted, tightly structured bill to offer a dignified death to those who are facing death.
Patricia Ferguson.
Thank you, Madam Deputy Speaker, and I rise to speak to my amendment number 13, which concerns the appointment of the Voluntary Assisted Dying Commissioner. During the committee stage of the bill, it was decided that the Prime Minister would appoint the Voluntary Assisted Dying Commissioner and that the appointee would serve 5 years and be responsible for appointing the Assisted Dying Review panels. The Commissioner would also oversee the training of panel members, give them guidance on the procedures to be used, and, crucially, decide when a case that a panel has refused should be referred to another panel for reconsideration. The Commissioner will not, according to the bill, be acting as a judge, but must be a current or former senior judge of the Supreme Court, Court of Appeal or High Court, but is not required to have any expertise in medicine or healthcare. And importantly, following committee stage, the bill no longer requires that the Chief Medical Officer be responsible for monitoring whether or not the assisted dying regime complies with law. That responsibility has now been transferred to the Voluntary Assisted Dying Commissioner. So the person who is in charge of making the process, the person who is in charge of creating the panels, will also be the person who decides whether or not the Act is being administered correctly in that regard.
Would you give way?
I certainly will.
Given the scandals that we've seen in healthcare over many years, from infected blood to medicines which shouldn't have been prescribed to people, to things that happened at mid-staff, that having that independent and robust oversight from the Chief Medical Officer is a really a good way forward if people are going to be able to trust this legislation if it comes into law.
I thank the member for his intervention, and I think he does make a very, very valid point. And I think that the point of my amendment, and I will come to this, is that we need to ensure there is as much scrutiny as possible in this regard. Now, clearly from what I've outlined, this is an exceptionally important post, and one which carries great responsibility and significant power. Indeed, it seems to me that the post holder will require the judgment of Solomon to be able to fulfil their role. So it's surprising, therefore, that as the bill stands, there is no requirement for pre-scrutiny of the appointment by the relevant select committee, despite the profile of the post and the controversy that I think it will inevitably attract. Now, considering that such pre-appointment scrutiny is required for the chair of the Competition and Markets Authority, for the chair of the BBC, the chair of the Charity Commission, the Information Commissioner, the Chair of the Care Quality Commission, the Health Service Commissioner for England, the Chair of the Judicial Appointments Commission, and the Chair of the UK Statistics Authority, the omission of such scrutiny in this case is clearly a serious oversight, which my amendment seeks to remedy by ensuring that the correct select committee does have that power of scrutiny over this bill. Mr. Speaker, in my view, Madam Deputy Speaker, in my view, we need to guard the rights and privileges of Parliament very jealously. We need to ensure that this Parliament is involved in the scrutiny of this bill going forward as much as it possibly can be. And the bill itself requires to be as rigorous and transparent as is possible. No matter what side of the debate you're on, it is important, and we owe it to the people who send us here, the people who have been writing to us in such great numbers, to make sure that this bill is as strong and as good as it possibly can be. And my amendment seeks to make sure that in that regard, in regard of the Voluntary Assisted Dying Commissioner, it is stronger than the bill currently allows.
Dr. Caroline Johnson.
Thank you, Madam Deputy Speaker, and I refer to honourable members to my register of interest as an NHS consultant paediatrician. The debate so far has primarily focused on ethical consideration, legal frameworks and who will be eligible, the who, the when and the why, but I want to focus my remarks today on the how. As a doctor, Madam Deputy Speaker, I know that various drugs in different combinations can be fatal. In other words, there is more than one way to kill people. But which would be the best if that is what we wished to do? Which would be the most comfortable, and how do we know? For example, some forms of assisted dying use neuromuscular blockades, and in common parlance that means they paralyse you. Imagine a situation where you're in a lot of pain and someone gives you such a drug. To the outside you would look relaxed and peaceful as your muscles relaxed, but inside you'd be in a lot of pain and unable to express that to anybody else. Do we want people to be comfortable and know they're comfortable, or only appear comfortable to us? Clearly we want them to be comfortable inside as well, and so we need to have drugs that are properly understood and properly regulated for this purpose. Assisted dying is often portrayed as safe, peaceful and controlled, but the reality in comparable countries where it's been legalised so far is more complicated. Technical difficulties frequently arise, leading to complications, causing greater suffering, requiring intervention and potentially leading to a prolonged and painful death. A report in the British Medical Journal by Dr. Susie Lishman, who's a former president of the Royal College of Pathologists, and I should say works at the same trust as I do, showed there is a lack of reliable data on effectiveness and safety of drugs used, largely due to inconsistent reporting in jurisdictions where such dying is legal. In Belgium, it's estimated that only 52% of euthanasia cases are reported to the Federal Euthanasia and Control and Evaluation Committee. During a select committee visit to Oregon to discuss assisted dying in the last Parliament, which I went on and two honourable members from the other benches all went on as well, we heard about the complications being unknown in 71% of cases. There was no healthcare professional present when the drugs were given, so we couldn't really know. And we didn't even know if the drugs had been taken in some cases, but where we did, we found a history of seizures, of vomiting and of prolonged deaths. And in 9 cases in Oregon in 2023, there were 9 cases of patients having reawakened later on having been given these drugs. How do they feel in the intervening time? It is difficult for us to know. In Washington, a 2018 report found that 31% of patients took more than 90 minutes to die. I would also remind honourable members that an absence of evidence that things are going well is not an evidence of absence of things going wrong. I will give way.
I thank the Honourable Lady for giving way and for so eloquently describing some of the variation in the use of drugs in the case of assisted dying. Would she agree with me that in normal practice we have a yellow card scheme which allows for any adverse events from ingestion of prescribed medication to be reported? Is it her understanding that under the current proposals this would not happen for assisted dying? And is she also aware of a review that shows a great variation in the range of drugs used and in the dosage used?
I thank the Honourable Lady for intervention. I think one of the key problems with this form of intervention compared with others is the fact that we can't ask the patients afterwards how that felt. We can't get their feedback because they are dead. And so we can't, if we're going to give them things like particularly neuromuscular blockade or sedatives, we may not be able to tell. And there are physiological ways you can monitor patients and get some idea perhaps from their heart rate or their blood pressure, but we're not going to be doing that. And so that's one of the reasons that I have put forward the amendments I've put forward today, to ensure that the drugs are properly regulated by the MHRA so that we know that the drugs have been properly tested for the purpose for which they're being used. I've not got very much time, and I don't want Mr. Speaker to get Madam Deputy Speaker to get another return of that cough. If one examines the litany of drugs involved in other jurisdictions where assisted dying is legal, it makes for troubling reading. It's often an ad hoc cocktail of lethal substances, including sedatives, analgesics, cardiotoxic agents, neuromuscular blockers, and antiemetics. There's no internationally agreed drug regime. Jurisdictions such as Oregon, Canada, and the Netherlands use varying combinations of barbiturates, sedatives, opiates, and antiemetics. In 2020, the official Oregon report stated that compared with single barbiturates, all drug combinations have shown longer median times until death. As it currently stands in this bill, doctors will have to consider prescribing untested drugs or drug combinations, which could potentially breach the GMC prescribing guidance that a doctor must be satisfied that the drug serves the patient's needs. So to address some of these concerns, I've tabled several amendments. Madam Deputy Speaker, Amendments 96 and 97 ensure that no drug can be approved under this Act unless there is a scientific consensus that it's effective and does not cause undue pain or side effects, and that it's been specifically licensed for that purpose by the MHRA. And I cannot really understand why anyone would disagree with that. Amendment 98 clarifies the Secretary of State is not compelled to approve any drug if after consultation it's concluded that no substance is appropriate or safe enough to meet the standard. And Amendment 99, alongside Amendment 100, mandates that before any regulations are laid before Parliament, a comprehensive report must be provided. This report must include time to death, possible complications including pain, and any likely side effect of the proposed substances. Again, I can't see why that would be controversial, because surely we all want everybody to be fully informed and make informed decisions, and these are part of making an informed decision. Amendment New Clause 13B requires that any medical devices for self-administration be approved by the MHA, and that the Secretary of State consult the MHRA before making any regulations. This is a basic safeguard we would expect in any medical intervention, and it should be a non-negotiable condition here. And finally, if Madam Deputy Speaker will allow me, Amendment 42 removes the time limit and therefore the pressure on the Secretary of State. I understand other people's concerns about this, but there's often a narrative that this will lead to patients being able to die at a time and a place of their choosing. But the regulations in this bill require the doctor to stay with the patient from the moment the drug is given until they are dead. And we've heard that this could take quite a long time. Do we really have enough doctors to do this at people's home at a time of their choosing? At the moment, I don't think we do. And I do not see how, in a short period of time, that will be achievable either.
Alex Barros-Curtis.
Thank you, Madam Deputy Speaker, and I'd like to stand in support of new clauses 20 and 21, along with amendments 89, 90, 92, 93, 94 and 95, all standing in the name of my honourable friend, the member for Spen Valley, but I will not speak to all of them. Colleagues, fear not. Given some of the discussion, I do want to focus on just a couple of aspects, given I am a proud Welsh MP, and a lot of the debate today has centred on differences or perhaps confusion about the distinction between devolution on aspects of this bill. Firstly, I'd like to focus on New Clause 21 and Consequential Amendment 90, and to this I pay tribute to my honourable friend, but also to the Honourable Member for Mariona for the work that I know they have done together on this, in order to ensure that people in Wales can access the assisted dying process in the Welsh language if that is their preference. In the last few months I've met with many constituents about this bill. Some have included medical professionals and palliative care consultants, and one of their overarching concerns was a fear that the barrier of language may inadvertently impact the ability of a relevant person in Wales to properly access and understand the assisted dying process. And I'm grateful to them, including Dr. Suan Seaman and Professor Mark Tauber. Accordingly, New Clause 21 and Amendment 90 are important because they seek to replace Clause 47 and provide that the form of the first or second declaration, the report about the first or second assessment of a person, or the final statement must make provision for the forms to be in Welsh. Further, it stipulates that where a relevant person informs the voluntary assisted dying commissioner that they wish to communicate in Welsh, the commissioner must take all reasonable steps to ensure that that wish is respected and that communications by the relevant assisted dying review panel are in Welsh. These are important amendments as they are about accessibility and respect, ensuring that language is never a barrier to compassionate end-of-life care. They uphold the principle of linguistic equality, which is well established in public services in Wales, and I trust that this should not be controversial to colleagues when this comes for a vote later on. And as a Welsh MP, I'm pleased to see the inclusion of amendments 92, 93, 94 and 95. Whilst they may appear seemingly small amendments, they are important because they respect fully, as my honourable friend said, they respect fully the devolution settlement by ensuring Welsh ministers have all necessary powers about devolved aspects of the bill, health, whilst retaining the powers of UK ministers over those aspects that are not devolved, something that I think got slightly misunderstood by some in this debate earlier. Taken together, they provide clarity and legal certainty, and they offer reassurance to patients, clinicians and government agencies in Wales. That principle should be uncontroversial, and I know from my own discussions with the Welsh Government and the Welsh Health Minister that he is extremely grateful for the interactions he has had with the Honourable Member for Spen Valley, and that he is confident that this is workable from the perspective of Wales. In respect of new clause 5, Madam Deputy Speaker, this seeks to mandate that the Secretary of State must within 6 months publish a report setting out the impact of this legislation on the civil procedure rules and probate proceedings. I do not recall during the debate and during the streams of evidence we have heard that there was a suggestion that this bill is necessarily likely to result in any serious changes to those specifically referenced matters. On the contrary, England's CMO, Professor Sir Chris Whitty, warned against creating a bureaucratic thicket and saying that the best safeguards were the simplest ones. So let us keep that in the centre of our mind when we are considering this legislation and avoid inserting, no doubt well-intentioned, but inserting amendments that will create such thickets. Madam Deputy Speaker, I would like to conclude by just sharing one story from a constituent of mine who was focused very much on safeguards, which has been a debate about all of these amendments and about the new clauses. I won't, because I just want to finish up. I appreciate his forbearance. That constituent was Claire O'Shea. Claire was originally diagnosed with IBS. It was only much later that they realised she had stage 4 cancer. Now, within an hour of this House voting to pass this bill at its second reading, Claire messaged me to say, "What a powerful debate today. It's hard to say I'm pleased, as it's a terrible issue to have to contemplate. But it's such a relief to know the next stage is open and hopefully allays the fears of those talking about safeguards." Madam Deputy Speaker, Claire lost her battle with cancer last month, so I am pleased that we are here again discussing the specifics of this bill and talking about amendments in good faith that either side thinks will enhance its safeguards. In honour of Claire and for all those like her, I urge colleagues to vote to support the clauses, amendments and new clauses I've outlined and to support the bill itself.
Thank you very much, Madam Deputy Speaker, and I rise to speak in support of Amendment 77A in my name, but I'll also refer to my register of interests in regards to the Royal College of Psychiatrists. Madam Deputy Speaker, now, new Clause 13 is, we are told, a replacement for Clause 34, and I would hope members have taken the time actually to compare the two, because new Clause 13 contains even more powers than Clause 34. It follows the trend of this bill where instead of more detail being added to the bill, more powers are added. And it seems to be the line is there are some issues which we will sort out later. But it seems to be that this place won't be involved actually in the later. So what is particularly concerning is that the powers it creates contain no explicit limit or guiding principle by which they are to be exercised. Nor do we have the benefit of a policy paper by the Secretary of State actually saying how he intends to exercise those powers, nor how his successors will either. So the provisions relating to the approved substances, Clause 25 in the new Clause 13, I believe face a real problem. As Dr. Greg Lawton, a barrister and pharmacist, told the committee in written evidence that the lethal substances intended to end life are not medicinal products, actually within the meaning of the Human Medicines Regulation 2012. And that's a definition which itself derives itself from EU law. And as it actually states that that term, medicinal product, must be interpreted as not covering substances whose effects merely modify psychological functions and which are not such as to entail immediate or long-term beneficial effects for human health. Madam Deputy Speaker, that creates the real problem. So if it's not a medicinal product, then why does the bill provide that pharmacists are to be involved in the preparation of it, and why are doctors supplying it? I'll make a little bit of progress. Because new clause 13.4 seeks to get around this problem by giving the power to the Secretary of State to amend the Human Medicines Regulation 2012, actually to make them fit in. So the impact assessment tells us that the government has no plans to conduct or rely on the sort of scientific studies that are normally done for drug approvals, nor with the MHRA actually be involved. I'll give it.
I would like to thank the Honourable Member for giving way, and thank you, Madam Deputy Speaker. As a pharmacist, as you know, the drugs that are going to be used for assisted dying are commonly used in pharmacy now. So it would be obvious for pharmacies to supply, in some way, shape or form, those drugs. And I accept his point about medicines being used, but he must accept my point, I hope, that how would the same studies that are used to prove treatments be used to prove the use for death?
And I think the member said in an earlier intervention as well that those medicines then would be used off licence, and at the risk of the prescribing doctor and the person using them as well. So that's where the risk falls back on the individual rather than anything that's actually covered in regards to this bill. Because that's where my regret comes, because I do not understand the need to treat them as medicinal products in England and Wales in that case, but I do see it if it is the will of this House to change the law here. But what I cannot understand is why this law now changes that for the rest of the United Kingdom. And indeed that's where the base of my amendment 77A, because this House is not voting for assisted dying in Northern Ireland. So it has no locus in changing the definition of a medicinal product in Northern Ireland in order to accommodate this bill, which after all we've been told applies only to England and Wales, unless it is the intent of the bill's sponsor or those behind it at a later date to extend it to Northern Ireland using some of the Henry VIII regulations in it. There is a further issue in Northern Ireland. We are still part subject to EU law, and on this point I would be very interested to know where the government has considered this aspect in that regard. So can the Minister really change EU law in Northern Ireland in regards to the use of these substances by ministerial diktat? And if so, why has it not been granted for such power in other areas of significance to Northern Ireland? Why only this? Or why has so much government time previously spent working on medicine regulation and supply for Northern Ireland? Or why did the Right Honourable Member for Milton and Spey, when he was the Minister of State for Health, and I as the Minister of Health in Northern Ireland, spend so much time on it? So to that extent, can I ask the sponsor, or indeed the Minister, what engagement there has been with the Department of Health, or the Minister of Health in Northern Ireland, or indeed the Chief Pharmaceutical Officer for Chief Pharmacist in Northern Ireland? Or is this another section of the bill which has been put in without any background or any engagement just to meet the sponsor's needs? Madam Deputy Speaker, in that regard, in conclusion, the application of those provisions to Northern Ireland also has implications on the conscience protection, because if as a result of these regulations are made under these provisions, pharmacists in Northern Ireland are required to be involved in the manufacture or preparation of those substances, and they will not have the benefit of the conscience clause, as that clause has not been extended to Northern Ireland in this bill. I therefore oppose the extension of this provision to Northern Ireland and Scotland, and I will oppose Amendment 77 and ask others to support the amendment in my name of 77.
Blair McDougall.
Thank you, Madam Deputy Speaker. I rise to speak in support of amendment number 15 in my name, and I'll minimise my comments in order to maximise others' time in this debate. Madam Deputy Speaker, because of the widespread unease from NHS practitioners, because of the growing number of voices of concern about the shortcomings of this bill, it seems that if this legislation is passed, and I still hope that it won't be, but if it does get passed by this House, then it's likely that assisted deaths will take place away from the public sector. Indeed, this bill does not prevent assisted deaths from being outsourced to private companies. There is no definition of what reasonable remuneration means in return for helping end someone's life. My amendment seeks to ensure that providers publish on an annual basis the numbers they've provided those services to, the costs of doing so, and the revenues received in return. Madam Deputy Speaker, I know that many will be guided in this debate by their religion when they vote on these issues, and though I respect that deeply, I am not a person of faith. If there is a booming baritone voice appealing to my conscience, it's not that of God, but of Nye Bevan and his concern about the commodification of care. In his time, the worry was about the role of the market in extending life. Today, my concern is about the role, or the potential role, of the market in ending it. Throughout the passage of this bill, we've discussed coercion of different kinds by individuals in the lives of people whose protection is entrusted to us. As a Labour MP, I don't think we can have this debate without addressing the economic coercion experienced by the vulnerable in our society. I genuinely understand, as someone who has sat beside a bed and prayed for mercy, I understand the attraction of the arguments around choice. But for me, again as a Labour MP, arguing for freedom of choice as a fundamental principle in isolation, without also acknowledging the economic, social and cultural context that people make those choices in, is not, for me, it seems, a Labour approach to this. I will give way.
Would the honourable member agree with me? No matter how many clauses or bills we put through, we cannot mitigate for the fact that people are vulnerable, and in particularly financially vulnerable. According to the charity Mind, 2.7 million people consider suicide in this country because of financial hardship. How would we mitigate for that?
I think he makes an important point, and one that we have to consider today. We must recognise the choices, as the Honourable Gentleman says, that people make are limited by the unfair distribution of wealth, the injustices that disabled people face throughout their lives, or the attitudes of the powerful in society towards those who are less fortunate. We have happily, yes.
Just a very short comment, and thank you for giving way. Actually, if you look at the statistics, it's usually the weller off in society that choose assisted dying, not the actual less well off.
I'll come to that point shortly as it happens. But I think we have a duty to ask, will the poorest and most vulnerable be coerced into choosing assisted dying over palliative care through economic disadvantage? Will they be exploited by those with a financial interest in them choosing to end their life? And will their death become a commodity? And if we are really going to pass legislation that allows someone's death to become a matter of business, we must, as my amendment suggests, have full transparency on those financial motivations. It isn't, Madam Deputy Speaker, that carers in the private sector are bad people any more than people working directly within the NHS are. But private healthcare operates in a context. The evidence that profit influences on the moral choices made across the care and treatment already provided in this country is overwhelming. This is not a hypothetical concern. For example, a systematic review published by the BMJ found that private equity ownership of healthcare is associated with lower standards of care. Around the wonderful miracle of IVF, we have an industry profiting from people's desperation as they start life rather than end life. And already today, and this relates to the point from my honourable friend in front of me, already at the end of life, choice in palliative care is limited by economic status, with the wealthy more likely to die a good death than the poor. This amendment seeks to address the fundamental question of whether free choice really is free by bringing into daylight the financial motivations of those involved in individuals' decisions. Sorry. Yes.
I thank the Honourable Gentleman for giving way on that point, and he makes a very strong argument about why we should be excluding private for-profit providers from provision. During the Bill Committee, he may know that I laid an amendment specifically to limit the provision of assisted dying to charities, but unfortunately that amendment was rejected. Would he be able to clarify where and how he thinks assisted dying should be, and what his understanding is on the basis of this bill and the lack of clarification we've had from the member for Spen Valley? Thank you.
Thank you, Madam Speaker. I think she makes an important point. I think this amendment seeks to recognise that there is a difference in where the income stream comes from, and there are moral issues raised by that. I'm going to make some. I don't wish to exacerbate Madam Deputy Speaker's bronchitis, so I'm going to continue. This amendment touches on that fundamental point at the heart of the debate. Disabled people and the sick in every aspect of their life have to fight every day for resources from a state, a market and a society that views them as a drain on finances. Do we honestly believe that at the moment when the most vulnerable are least able to argue for themselves, at the moment where they're under the most intense societal and cultural pressure, at the moment where they are at their most expensive, that same public and private sector will succeed in making choice real for them when it's failed to do so throughout the rest of their lives? Even if we stretch credulity and can convince ourselves that that would be true in the state sector, can we say that it will be true from the market? I don't believe this bill should be passed, but if it is, let's not make it worse by allowing unscrutinised profit from the loss of human beings.
Thank you very much indeed, Madam Deputy Speaker, and I rise to support new clause 14B, new clause 1, new clause 2, 16, 15A and 14A. I just make two observations, Madam Deputy Speaker, if I may. I do so as a Welshman representing an English constituency, somebody who chaired the Northern Ireland Affairs Select Committee and somebody who chairs the Public Administration and Constitutional Affairs Committee. I remain to be convinced that the confidence expressed by the proposer of this bill, that it honours in the spirit and the letter the devolution settlement, is true. And if she had been able to see the expression on the face of her honourable friend, the chair of the Scottish Affairs Select Committee, I don't believe the honourable lady believes that it honours the devolution settlement as far as Scotland is concerned either. And I also make this point, and I know how easy it is because I know it is a trap that I have fallen into. We are here to make law which has to stand the test of time. The Honourable Lady for North Herefordshire, she was not the only one, has shared a very heartfelt anecdote of a conversation with her mother as a result of her mother's professional work. We should not and cannot, particularly on an issue as emotive and as life-changing, literally, as this bill, we should not base our decision just on anecdote, but on cold analysis of what is before us. Now, it's been almost 6 months to the day since this bill was introduced, and still I think it is best described as being skeletal. We have been told time and again by the Honourable Lady and the Minister how busy officials have been looking at the practicalities of the bill and how to operationalise it and to make it workable. And yet this House is kept in the dark on what ministers intend. Indeed, the Honourable Gentleman, the member for Folkestone and Hythe, said in his earlier contribution that his understanding was that the Honourable Lady for Spen Valley was still prepared to work with colleagues to perfect the bill. But, Madam Deputy Speaker, we're on the second day of report stage. We could easily fall to third reading today. The time for that evolutionary conversation is long past. The time for detailed clarification is now. The bill remains skeletal. The most common phrase in the government's impact assessment, not known, 26 times, unknown, 8 times. It's left to the Times to ferret out that ministers are thinking of outsourcing ending the lives of the terminally ill to private contractors on a for-profit basis. The Honourable Gentleman who spoke before reference Nye Bevan. I can hear Nye spinning in his grave at the thought of that. Rather than fill in the blanks and constrain the powers to be given to ministers, even more Henry VIII powers have been added. Henry VIII powers which were not in the original bill. We were told, and I know full well that many honourable and right honourable members bought this, that the role of the committee and further stages of this bill would provide all of the answers, dot all the I's, cross all the T's, provide the full clarification. Now, that has not happened. And this House rightly bridles when ministers of the Crown bring forward legislation which has an unhealthy reliance on Henry VIII powers. If we do it on other legislation, we certainly should bridle at it for this. It is beginning to feel, Madam Deputy Speaker, as if this were a deliberate tactic. Keep things vague. Don't make anything too real or tangible. Don't confront what this will mean day to day. Let's just keep it light. Let's keep it airy-fairy. Let's keep it in the cloud of principle, and somehow or another, through benign intervention, good will accrue. I think that this is too serious an issue to place that faith, because placing that faith could be misplaced. It relies on us as members of Parliament to not care, to switch off when we hear the words secondary legislation, something which we know that can often take place in 5 or 10 minutes in a committee room of 14 or 20 people selected by the whips, no debate on the floor of the House. This is not a niche issue for the Hansard Society or the Delegated Powers and Regulatory Reform Committee, and it would be a shame and a stain on this House, in this Parliament, if we just nod through a bill which gives us this idea that Henry VIII is the way to go. I won't. I'm very conscious of time. But, Madam Deputy Speaker, of itself, the fact that so many right honourable and honourable members have been constrained in the length of their interventions because of your persistent cough, I say that not as a criticism, when next week we have a lot of one-line whips and the following week we have exactly the same, more time really should be given to this. And I do wish the government had taken this on not as a government bill, but had found committee report stage time on the floor of the House in government time. This is too serious an issue to have as many gaps and lacunas that this bill has. The founding fathers of the United States worked on the basis that the vague generalities of the Constitution would always be adhered to and that men and women of goodwill would adhere to it. They are now beginning, I'm pretty certain posthumously, with the current incarnation to wonder if that is true. We should not be legislating where we leave it up to ministers to define and decide how regulations come forward. We have bills which have page after page after page, which when people think to themselves, what is this all about, actually amounts to very little. The amendments which have been tabled and which I support have been tabled in good faith. But I'm afraid to say, I think in terms of trying to improve this bill, it is trying to make a silk purse out of a sow's ear.
Catherine Fuchs.
Diolch, Madam Deputy Speaker. I rise to support NC20, NC21, as well as Amendments 70, 71 and 92 to 95. They are all about the right of people, they are all about the right people having the right powers at the right time. And in terms of the amendments, respecting the devolution settlement for Wales. I'm mindful of time and therefore I will not take interventions. I'm really sorry to other honourable members. I'm extremely grateful to the member for Spen Valley for engaging so meaningfully and strongly with the Welsh Government, including going to Cardiff to speak with the Welsh Health Ministers and officials to ensure they are continually consulted during this process. So starting with new clause 20, it ensures that it is the Secretary of State, not the Chief Medical Officer, who's responsible for issuing guidance on the operation of the bill. It enhances oversight and accountability by placing this responsibility with the Secretary of State. The scrutiny and accountability of how this law will be implemented in practice
is put in the right place. It is normal practice that officials whose roles and responsibilities may alter over time are not named in primary legislation. It's important to note, however, that the Chief Medical Officer is definitely not being cut out of the process. The Chief Medical Officers for England and Wales must be consulted. The amendments also allow persons with learning disabilities and other protected characteristics, as well as providers of palliative care services, to contribute to the process of provisioning guidance. So it's a simple but important amendment that ensures the right level of ministerial oversight, and I urge colleagues to support it. Moving on now to new clause 21. As my honourable friend for Cardiff West has already explained, it's important to urge people to support this part of the amendment because it ensures that people in Wales are able to access the assisted dying process in the Welsh language if that is their preference. Almost 30% of the population in Wales speaks Welsh, and it's so important that they can access this service in their language should they wish to. So it's a small change, but it will make a huge difference to patients, families and clinicians in Wales. Moving on to Amendment 1771, they simply refine the provisions around the use of interpreters, requiring the Secretary of State to publish a code of practice on this matter. Interpreters are essential to ensure fair and equal access to the assisted dying process for those whose first language is not English or Welsh. On Amendments 92 and 93, they provide greater detail on the Welsh Government's responsibilities in delivering assisted dying services in Wales. Some honourable members seem to be confused about what is and isn't devolved, but as a Welsh MP, I wholeheartedly support this amendment, which 100% respects devolution. It ensures that Welsh ministers have all the powers they need with regard to the devolved aspects of the bill, the health provisions, while retaining the powers of UK ministers over those aspects that are not devolved, the criminal justice provisions, including, crucially, the changes to the Suicide Act. Finally, on the amendments, Madam Deputy Speaker, I support Amendments 94 and 95, which clarify how and when provisions relating to voluntary assisted dying will come into force in Wales. These do not impinge on the devolution settlement, but simply provide clarity and legal certainty. All of these amendments would help my constituent, Noah, a 19-year-old with a terminal brain tumour, who knows what he wants if his pain becomes unbearable. This bill is about giving people like Noah the choice, control and compassion they deserve at the end of life. And who are we to deny that choice? In conclusion, I want to pay tribute once again to my honourable friend, the member for Spen Valley, for working closely with officials in both Wales and in this place to craft what could be the strongest and most safeguarded assisted dying legislation anywhere in the world. It is a bill designed to protect everyone, including my constituents in Monmouthshire and people across Wales. Thanks to the careful, considered amendments, including the ones I rise to support today, it not only respects the devolution settlement, it ensures the right people hold the right powers at the right time to deliver this law safely. I urge other members to join me in the iLobby as we legislate to protect the rights of the terminally ill in their final months, to legislate for compassion, for choice and for dignity.
Savile Roberts.
I rise to speak in relation to the amendments 39, 40 and 41 in my name, which regard Clause 47, the provision of information in Welsh and English, and also, of course, new Clause 21, which has been laid down by the sponsor for this bill. The issues here, and others have touched on the Welsh language, and I want to touch on the settlement in Wales as well, but in relation to the Welsh language, what we are talking about here is something that is quite conventional in the sense of written Welsh being available for forms and guidance, but way more significant is the availability of people who wish to use Welsh Welsh may well be their first language in dealing with the stages of this, the provisions provided by this bill. So we have the all reasonable steps in relation to being able to find a coordinating doctor and an independent doctor. I would dearly like to say I would write more than all reasonable steps, but the reality is we have to deal with the staff who are available and the language skills that they have. But the third stage, and I'm very, very glad, I'm appreciative of the Honourable Member for Spen Valley in also appreciating this in her new clause, is that it is really, really important for a Welsh-speaking individual to be able to communicate in the language in which they best express themselves when it comes to the assisted dying review panel. Because this is the final stage at which we will recognise whether there is a question of coercion, whether there is a question over capacity. I must also welcome the fact that there are different clinical specialists in this group. I believe that this improves the identification potential of questions of coercion and capacity by having an expert, a psychiatrist and a social worker, different approaches to those questions here. And I must just take a step back to the reality of how Welsh language speakers can use Welsh within justice, which of course is where the aspect of this, of the assisted dying review panel, comes in. In justice, you have, as an individual has the right to speak Welsh. If they use Welsh in a court, then an interpreter will be used to interpret their words to the people to whom they are speaking. That is not acceptable in this context. This is the most serious, the most desperately difficult conversations that people will have. They must be able to not just speak Welsh, but to be heard as well in their own language, if all the subtleties and what they really want to express is to be heard. So I would like to say now that I'm withdrawing my amendments 39, 40 and 41 and supporting new clause 21 wholeheartedly. Now I want to turn to the Senedd powers, and particularly in clause 54. Now, firstly, I welcome the clarity of responsibility as regards ministers in Welsh Government and UK Government in new clause 20. But there are two issues here. There is clarity of powers, but there is also respect across legislatures here, and this matters. Now, I have concerns over amendments made by the lead member, amendments 94 and 95, to the amendments that were made by the Honourable Member for Richmond Park in committee. What did those amendments in committee do? They ensured a vote in the Senedd to decide when the Act would come into force in its entirety in Wales. Now, in Scotland, they passed stage 2 of the Assisted Dying for Terminally Ill Adults Bill on the 13th of May. Such a bill could not be brought forward in Wales because Wales has no powers over criminal law. This bill that we are discussing here today could not be brought forward in Wales. So, although I appreciate what the Honourable Members for Cardiff West and Monmouthshire said about the devolution settlement, and I am glad that we have clarity, there is also a question of respect for decisions already made in the Senedd. So as things stand, what does the Senedd have to do? It will be required to pass a legislative consent motion as required by the Sewell Convention, but that can be ignored by here. This legislation affects action in Wales, but the Sewell Convention can be overridden and LCM can be overridden. Now, this is calling, therefore, for a vote, and the second thing, that can happen within the Senedd, and will be expected, is in those areas where there is the power of the Senedd. So, commencement, a decision is required on the provisions of the bill which have devolved competences, which is specifically the NHS in Wales. Now, bear in mind that if this is refused in Wales, that means that this bill, if enacted, can only be brought into the private sector. But that decision lies with the Senedd. Now, the critical point that a number of us have raised, though, previously today, is a debate on the 23rd of October last year, when the Senedd debated, in principle, the question of assisted dying, and the Senedd voted against this. Now, Professor Emil Lewis of Aberystwyth University believes this, and I agree with him, to be highly significant. That vote, by the way, included the First Minister and the Health Minister of Wales, who voted against the principle of what we are discussing here. Now, to me, therefore, the amendment that was made in committee which allows the Senedd to have a vote on the entirety of the commencement of this bill when it is enacted, is highly significant. And although I support very much of this bill in principle and in broad detail, I cannot support Amendments 94, 95 because they roll back on that.
Siobhan McDonald. Speaker, I would like to move Amendment 12 in my name. I want to be clear. A decision on Amendment 12 is not a vote for or against assisted dying. It's about preventing any government of any political persuasion from rewriting the very purpose of the NHS using a small group of MPs in a committee room rather than on the floor of this House. My amendment seeks to protect the foundational document of our NHS and ensure that any changes to it are properly debated in open Parliament as the public should expect. Let me explain why this matters. At committee stage, clause 38 was added to this bill. This clause gives a future Secretary of State sweeping powers to amend existing health law through delegated legislation. Subsection 4 of clause 38 allows a future government to change the very purpose of the NHS by amending Section 1 of the NHS Act 2006.
I thank the Honourable Lady for giving way, and she's setting out her concerns eloquently. What concerns does my honourable friend have that this bill writes a blank cheque for a future Health Secretary to change the nature of the NHS without parliamentary scrutiny?
That is the whole purpose of my amendment and my speech. Section 1 is the legal foundation on which every NHS duty rests, guaranteeing our NHS will serve everyone, always. This section has remained virtually unchanged since 1946 because it expresses a promise, a comprehensive health service designed to secure improvement in the physical and mental health of the people of England. Those words, spoken by Nye Bevan and enshrined in law, set the purpose of the NHS, a national health service free at the point of delivery.
Intervention is taken. Can I just put on the record, members should not be wandering into the chamber and then very quickly making an intervention. Lots of other members are waiting to speak and make interventions, if that is the case. But have you been in the chamber for a while? Yes. Okay, go.
I did use the facilities, Madam Deputy Speaker, so I apologise for that. I am a gentleman of an age. Sorry, I apologise. Can I thank my honourable friend for taking the intervention? We are about to reach the 80th anniversary of the landslide 1945 Labour government was set in train with the NHS and the 77th anniversary of the NHS. Fundamental to that is the point you make about the NHS being free at the point of need, about care, compassion and life. What assessment she made about how this bill, if it goes through unamended, will fundamentally challenge that great victory and legacy we on this side of the House cherish.
The power to be able to alter the intentions, as mentioned by the Honourable Member, was not in the bill we voted for in November. And that is why I have tabled my amendment, to prevent anyone from tampering with the NHS as founded by our forefathers. Because let's be clear about what clause 38 of this bill would allow. It would allow a minister, through delegated legislation, to rewrite the very purpose of our NHS.
Will the Honourable Lady give way?
It would let them do so without the full scrutiny that primary legislation demands. And it would mean Parliament could be denied any real chance to amend or reject that change. These are not abstract constitutional concerns. This is about whether the founding promise of the NHS can be quietly rewritten, not through open debate, not by an Act of Parliament, but by a handful of MPs behind closed doors in a committee room. And once the past is sold, there is no telling what future governments might do or undo. This is why this matters so deeply, because the NHS is not just a set of services, it's a promise made right here in this House nearly 80 years ago, during the second reading of the 1946 NHS Bill.
I thank my honourable friend for giving way. I think it's important for her to be able to explain in detail what these philosophical and institutional implications are. But fundamentally, for ordinary patients, what does my honourable friend think this bill will do about changing the relationship between the patient and the doctor?
Its potential is to alter everything in a very undemocratic manner. In this very chamber, Nye Bevan told us the NHS would lift the shadow from millions of homes, keep very many people alive who might otherwise be dead, relieve suffering, produce higher standards for the medical profession, and be a great contribution towards the well-being of the common people. We have a duty in this place to defend that promise. We cannot allow the promise to be reworded without the full voice of Parliament. We owe it to the public, to patients, and to NHS staff who dedicate their lives to this service to stand firm and protect what is sacred. The amendment is simple, but its impact is profound. It ensures that any future changes to the core principles of the NHS must be debated openly, transparently, and with the full consent of every member. No shortcuts, no sidestepping, no ministerial overreach. I urge colleagues across the House to support Amendment 12, to stand with our NHS, to stand with the people it serves. And I urge my side, the Labour side, not to allow the assisted dying bill to be the Trojan horse that breaks the NHS. The proudest institution, the proudest measure introduced by our party in 120 years.
Thank you, Madam Deputy Speaker. I rise to speak in support of Amendments 21, 103, 104 and 42, tabled by my honourable friends for Twickenham, Newcastle-under-Lyme and Wimbledon. As other members have said, this is a deeply consequential bill. I want to record my thanks to the honourable member for Spen Valley, to all members of the Bill Committee and to all those who have contributed to the careful scrutiny of this bill through the tabling of amendments and our debates over them. This bill is about the end of life. It is an emotive and sometimes painful topic, and I am grateful to my many constituents who have generously shared with me their experiences and opinions. I've also taken some time to consult palliative care practitioners, including those providing hospice care in my constituency. Those conversations reinforced the awe and admiration I hold for these caring professionals. Their expertise and deep commitment is always impressive. Contrary to the points made earlier by the Honourable Member for Gosport, they are adamant that they can provide sufficient pain relief to the vast majority of those receiving end-of-life care. The issue is not about the efficacy of treatment, it is about access to it. And in this, I echo the powerful points of the member for East Renfrewshire on the present inequality of access to palliative care. Amendment 21 would ensure that the availability, quality and distribution of palliative and end-of-life care is published within 1 year of the Act being passed. When assessing the provision of end-of-life care, it is critical that this House and the public can see how palliative care is being delivered. I strongly believe that for the measures in this bill to provide a genuine choice to those at end of life, palliative care must be much more widely available. The Honourable Member for Spen Valley argues that there should be no false choice between palliative care and assisted dying. Yet she and health ministers know that there is a choice since resources are limited. When so many hospices have closed beds due to funding shortages and receive more than 70% of their funding from donations, I am concerned that we may see significant expenditures on a new regime for assisted dying funded by the state as a health treatment, while the palliative care sector, and hospices in particular, remain chronically underfunded. Only by having the assessment, I will not give way, only by having the assessment of the palliative care system proposed in Amendment 21 can we be confident of knowing whether access to palliative care is sufficient. If we are to provide a true choice at end of life, this is critical. Madam Deputy Speaker, I also stand to support Amendments 103, 104 and 42. Amendments 103 and 104 would give this House a say over the key decisions that still remain to be taken about the implementation of this bill. Given the significance of the bill and the importance of the many questions still to be resolved, these amendments are critical. Amendment 42 would ensure that we do not career towards the enactment of this bill in 4 years, whether or not the system is ready to operate safely and fairly. Taken together with Amendments 21, 103 and 104, this would ensure that this House has the chance to consider whether those at end of life can access the full range of support, advice and protections intended by the bill, and that they deserve from palliative care services across the country. Madam Deputy Speaker, like so many in this House, I have direct personal experience of the issues addressed by this bill. My father was diagnosed with stage 4 cancer in May 2002. Over the next 7 weeks, he and my family benefited from the incredible care of our local hospice. Sharing my dad's life, care and death has shaped me, so I fully understand why so many of my constituents have asked me to vote on this legislation in light of their and their loved ones' experience. Yet, Madam Deputy Speaker, our task here is to legislate for a new system that will affect thousands of people and society as a whole. I firmly believe that however this House votes on this bill, our debates must result in a new focus on the provision of palliative care so that all people at end of life truly have options in the management of their care and death.
Deputy Speaker, I rise to support the amendments of my right honourable friend, the member for Walsall, who sadly can't be here today. That's Group 2, Amendments 34, 35, 36 and New Clause 6. They're on ethnicity. It's a health inequality that shapes life expectancy and outcomes, and COVID deaths illuminated this, but it's absent from this bill. A younger me would have been 100% behind this bill. I'm very pro-bodily autonomy on abortion, but 10 years of being an MP has exposed me to coercion, duress, the millionaire price of London property and elder abuse, and it's no coincidence a majority of London MPs and a majority of BNE MPs oppose this, as do I. So let's look at Amendment 34. The experience of my aged parents, now no longer with us, opened my eyes to a world of pills, incontinence pads, hoists, power of attorney, key safe box, carer worries, and I saw how non-native English-speaking pensioners, and I'm not talking about Welsh speakers, have their agency denied by health professionals in a stretched system, maybe unconsciously, as it is. So my mum's GP, who had clear contempt for her accented words, who said to her, one question only every appointment. And then by the time she made it to hospital, frail and losing the power of speech, reverting to her mother tongue, they saw her as an annoyance, time waster, bed blocker. Similarly, the way that the disabled are often written off, people cannot see beyond the wheelchair, the non-verbal. And so this Amendment 34 would place a duty on the Chief Medical Officer to provide information at every step of the way. Do I get more time?
I thank the Honourable Lady. I recognise the time constraint. On the issue of vulnerable groups, you may know that there has been a letter sent on the issue of eating disorders, and the spokesperson for the bill's sponsor dismissed this, saying that their concerns were old news. Do you agree that there's a problem with the way that this bill has been run, that so often the concerns and evidence of groups with issues have been dismissed out of hand?
I totally agree with you. I mean, we know that Esther Ranson wants this, we know Jonathan Dimbleby wants this, but our role is to be voice of the voiceless as well. And so I totally agree with her. And as opposed to the sort of vague, ever-changing qualifying criteria that gets held up as safeguards, at least these amendments would put ethnic minority people on the board. If they're on the board, new clause 6, they should be on the board as well. But it just seems to neglect them altogether. So this would provide real protections. And we know that in a cost of living crisis, assisted dying could be quite attractive. We know that BAME communities have lower disposable household income than standard households. Yeah. And you can just imagine relatives in a cost of living crisis, in a housing crisis, wanting to speed up granddad's probate, to get a foot on the ladder, or granny, or nanny-ma, or daddy-ma even. Convincing herself, or no, I won't, because I'm not getting any more time, am I? Convincing themselves that, look, they'd be better off out the way, given the cost of care, to get the younger generation on the ladder. And once it is allowed, we know everywhere else it broadens. 12-year-old depressed people in Holland can get this. We know that the incentive to fix palliative care will lessen. Why now with the state of the NHS? What of Suicide Prevention Week? Yes, we know that public opinion is for this, but you could say the same. Public opinion also supports bringing back hanging. No, I'm not going to. And look, I've had people pointing out the unfairness at my advice surgery of the cost of Dignitas, 10k. And yes, we know the status quo is imperfect, but let's not remedy it with something that will make things worse. Yeah. We need to get this 100% right if we're going to do it at all. So this bill, while well-intended, has too much room for error, manipulation, misapplication and unintended consequences. 6 months to live is impossible to predict, and with life and death, it's too late to change your mind once the latter's happened, isn't it? 1,000 doctors this week have argued it will widen inequalities and is simply not safe. These amendments strengthen the bill by taking ethnic minorities into account when hitherto they've been completely unacknowledged by it. They must be incorporated into any assisted dying, but obviously, best thing of all would be not to run down this road, not to rush down this road with indecent haste in the first place, as it's so littered with obstacles.
Richard Tice.
Thank you, Madam Deputy Speaker. And I rise to support new clauses 13, 14, 15, and to oppose Amendment 42, and to commend the Honourable Member for Spen Valley for the way that she has navigated this incredibly difficult and sensitive process. In considering these clauses and the passage of this bill, I've kept in mind the simple but difficult word pain, because this actually is about those who face a certain death in unimaginable pain, and its relationship with palliative care and the word choice. I won't actually, because so many want to speak. I think that we are lucky enough in this country to know we have some of the finest palliative care in the world. And it is a noble aspiration to want to improve that, to be the best in the world. But nevertheless, many of us will have seen loved ones, family and friends suffer huge pain in the finest palliative care. And the trauma that leaves on those left behind can be so painful and enduring. And I think that's why we are where we are. But for me, Madam Deputy Speaker, I think it's unfair because so many want to speak. I think for me, Madam Deputy Speaker, in considering this, I think that, yes, let's improve palliative care, but let's remember that actually choice, when faced with certain unimaginable pain, is actually the right thing to do. And that's why I will be supporting this bill. Thank you, Madam Deputy Speaker.
Lynnie Ward. Thank you, Madam Deputy Speaker, and I hope that members will understand that I am almost in my 13th hour of trying to speak on this topic, so I'm not going to take any interventions. I rise to speak in support of new clause 4 laid by my honourable friend for Peterborough, Amendment 14B laid by my honourable friend from Rochdale, and Amendment 13 laid by my honourable friend from Glasgow West. Let me start by saying that ending suffering is a shared goal of all across this House. Yeah. No one has a monopoly on wanting to end suffering. The question is about how we best do this. As a former aid worker and someone who has risked my own life in order to alleviate the suffering of total strangers in war zones,
I promise you that I am motivated to end suffering at least as much as the next member.
Yeah.
It is worth the House knowing too that my darling dad died of terminal cancer in a hospice run and funded by a charity because the NHS doesn't have that provision. Now, new clause 4 matters because we do not live in an equal society, although many of us, particularly on these benches, seek to bring one about. This is a deeply flawed bill, and the truth is that in seeking to give choice to some, it risks causing new harm to a much larger, vulnerable group of our citizens. And the safeguards which were watered down in committee stage will not prevent this. Indeed, a letter from over 1,000 doctors this week said the bill will widen inequalities and, quote, it is simply not safe. We heard earlier from the Honourable Member for Rochdale powerfully about the impact of advertising on the most vulnerable. And new clause 4 increases data about the impact on the most vulnerable and brings in proper oversight from the Chief Medical Officer, including in relation to those with protected characteristics. Last time we debated this bill, we heard from my honourable friend, the member for Bexley Heath and Crayford. We are in the shared situation of having close and dearly loved family members who have complex disabilities. My honourable friend and our families both know how it is to have to struggle to fight every week for the access to basic state services that our loved one is entitled to but cannot access. Services and precious state resources that would increase their equality and ability to live well, but were stretched beyond breaking point by successive Tory governments. It is that experience, Madam Deputy Speaker, that brought me into politics and into the Labour Party. And still to this day, away from my day job as a member of this House, I have to fight on behalf of my loved one, who has significant physical impairments as well as learning difficulties, to access the healthcare and support that they desperately need. Vulnerable people do not always make decisions in their own best interests, and I know too from my family experience that vulnerable people can be highly susceptible to pressure from others who do not have their best interests at heart. That's why the transparency of new clause 4 matters. I remind the House too that the Royal College of Psychiatrists had described the so-called safeguards in this bill as inadequate, and in Washington State, almost 2/3 of those who last had an assisted death in the year where data is available cited fear of being a burden on their family, friends or caregivers as a reason for doing so. I do not want that to happen in our country. Over 350 disability rights organisations oppose this bill as it stands. One of my constituents told me this bill contributes to a sense amongst disabled people, and I quote, that we are disposable. Amendment 13 and new clause 4 both make important changes to the Voluntary Assisted Dying Commissioner. I said to my honourable friends on the Labour benches, have you questioned the wisdom of the Prime Minister himself, having to personally appoint the Death Czar, as the media has christened that role, shortly before the next general election? Finally, earlier this week I heard an honourable member say that he believes this bill is flawed, but plans to vote for it anyway, so that it becomes law and we would have to sort out the problems later. And we've heard more of that today. He did not specify how he thought this would happen or when. He's right that the bill is flawed. He's wrong that we can ignore those problems. To do so would be to fail in our job as legislators. Being in favour of these amendments and against this bill does not mean accepting the status quo, as some have tried to suggest. It means that we choose instead to protect the NHS, to work, to fight, to battle for a palliative care system that is worthy of those we represent, rather than diverting time and energy into people helping to kill themselves.
Neil Wilson.
Thank you very much, Madam Deputy Speaker. Whilst I am not opposed to the principle of assisted dying, I have a number of deep concerns about the content of this bill, the process by which we are legislating for such a monumental change, and, importantly, the context in which it would be enacted, given the numerous challenges facing our health and care services. And that is why I have tabled Amendment 21 in my name relating to palliative care and end-of-life needs, which has attracted cross-party support. I'm also grateful to the Honourable Member for Spen Valley for supporting this amendment, and I'd like to pay tribute to her today for kick-starting a debate about dying well, and in particular, palliative care, a topic which for far too long has been neglected by many of us, myself included. Amendment 21 requires the Secretary of State to lay a report before Parliament a year after the Act has passed, detailing the availability, quality and distribution of health services to those with palliative and end-of-life needs. Marie Curie estimates that 1 in 4 people who could benefit from specialist palliative end-of-life care do not receive it. And people who are poorer, less educated, and yes, non-white, are even less likely to receive it. And so, Madam Deputy Speaker, I was horrified, if I'm honest, by the speech made by the Honourable Member for Loughborough earlier today, because all of the data shows us that actually people from minority ethnic communities are less likely to access the healthcare services they deserve, in particular palliative care. There is a deep distrust of health services, and those of us who were in this place during the COVID pandemic saw that played out in real time in hospitals and care settings up and down the country. Far more people from minority ethnic communities lost their lives. Far more healthcare professionals from ethnic minorities were not protected in the way they should have been. And therefore, if as a result of this bill passing, those people are less likely to access palliative care, I'll give way in a moment, if those people from minority ethnic communities and disadvantaged communities are less likely to access palliative care as a result of the fear of this bill being passed, my fear is that actually, contrary to what is said by supporters of the bill, that more people will die a terrible, horrendous, traumatic and painful death rather than fewer, and they will be disproportionately from those communities. I give way.
I'd like to thank the member for giving way. She raises a really powerful and excellent point about the ethnic minorities that died during COVID, about their access to healthcare. As you would understand, that's also something of deep importance to myself as well. She's right about the need for greater palliative care, and I'm really glad, like she says, that this is a discussion that we are now having. I think we look at assisted dying around the world. I think the concern around, for example, ethnic minorities being more likely to access it, as the stats show, it's the other way around. They're far less likely to access it. Now, for me, that's like neither here nor there point. The question is, given that the safeguards are in place, is the process working well? But those are where the stats are going forward. I do say I take it in really good faith that she raises it, and I thank her for doing so.
I thank the Honourable Member for his intervention. I actually think the stats he cited undermine his own argument, because actually all of the data shows us that they're less likely to access the healthcare services they need. Therefore, they are less likely to end up accessing assisted dying. And actually, the Honourable Member for Stroud gave the game away, and he's acknowledging it now, that it tends to be more the wealthier people who access assisted dying, because they are the ones who have the choice. They have the services to have a meaningful choice. Now, so these inequalities deeply, deeply concern me. My grave concerns about this bill becoming law is that they are the ones who do not have the loudest voices or well-funded campaigns to support them. And I think this whole debate about inequalities in access to palliative care should be actually the topic of a debate on a separate day, and I hope we have the chance to have that, Madam Deputy Speaker. Marie Curie also warns that there's no realistic local or national plan to address the scale of the challenge, and that the whole system is in a perilous state due to a lack of sustainable funding and limited prioritisation of end-of-life care. A survey of integrated care boards in 2023 found that half had no plans to invest capital in palliative care services, and 40% admitted that their services were inadequate for the needs of their population. And whilst my Amendment 21 would not put a duty on the Secretary of State to put forward a plan to address the variable provision of care, as that is outside the scope of this bill, the proposed report would at least shine a much-needed spotlight, and I very much hope, provide a catalyst for change. Because if this bill passes, we will be in a position where assisted death is available universally on the NHS to those identified in this bill, but access to good palliative care is not. That, Madam Deputy Speaker, is not giving people a genuine choice at the end of their lives. And passing this amendment will not change that. In my view, it is a bare minimum first step to analyse and expose the gaps, which needs to go hand in hand with urgent action. And that is why today I have also been persuaded to support Amendment 42 in order that the parlous state of palliative care can start to be meaningfully addressed before this bill comes into force. And if it isn't in a better state, then this bill should not be enacted. I will happily give way.
I hear the arguments across the chamber, and thank you for giving way, around palliative care not being at the level we expect right now, and I accept that. But what I don't hear from members opposed to the bill is exactly what level of palliative care do we need to have in this country so that assisted dying can go hand in hand with that as a genuine option.
Wilson. I thank the honourable gentleman for his intervention. I note that both the Health and Care Committee and the honourable member for York opposite have undertaken a commission and a report into this. I think they will advise us. I'm aware I need to sit down. So I will just end by saying that I would like honourable members to support my honourable friends from Wimbledon and Richmond Park in their amendments to ensure that we are not allowing Henry VIII sweeping powers to implement this bill, which is so sensitive and so important, and that new Schedule 2, which collects very important monitoring data on how this bill or any assisted dying death service will operate. We need transparency.
Lloyd Hatton.
Thank you, Madam Deputy Speaker. I rise to speak in support of new Clause 15 and Amendment 54 and against new Clause 5. As members and right honourable members will no doubt be aware, new Clause 15 would not classify a death as suspicious or unexpected, and a full coroner's inquest would therefore not be needed. If this bill becomes law, assisted dying would be a legal, strictly regulated and well-monitored choice made freely by the individual concerned. To be abundantly clear to members here today, it is not assisted suicide. This piece of legislation concerns people who want to live, but who, faced with an inevitable, irreversible terminal diagnosis, want choice over the manner of their death. It is an important choice that removes some of the trauma and anxiety, not only for the patients themselves, but also from their families and their loved ones. New Clause 15 and its consequential amendment number 54 will ensure that families naturally grieving the loss of their loved ones are not subject to an invasive coroner's investigation completely needlessly. I will.
I've just been trying to intervene throughout this debate. I think it's very important to realise that if there is any suspicions around an assisted death, a coroner can still be involved. It doesn't exclude that, but it stops the automatic referral to a coroner.
I share the sentiment put forward by my honourable friend. I firmly believe that we should protect bereaved families against such a distressing ordeal being automatically put into place, particularly when the process, as set out in this bill, would already be both legal and transparent.
Would the honourable gentleman briefly give way?
I would like to make a little bit of progress, if I may. With this in mind, it makes practical sense to support new Clause 15. If we have passed legislation to permit assisted dying with the full weight of the law behind it, then we must also respect that choice in the way that we classify and record such deaths. These deaths would not be in any way unexpected or suspicious, and so to classify them as such would simply be inaccurate. And has already been touched on in great detail during today's debate, if passed, this bill would implement the most robust assisted dying framework anywhere in the world. The bill already includes multiple layers of oversight. In my view, the process is cautious, thorough and robustly safeguarded. A retrospective investigation would be to duplicate the process and risk suggesting wrongdoing when none has occurred.
Will you take an intervention just briefly?
I will briefly.
I'm very grateful for the intervention. I just wondered what the honourable member's view was of the opinion of the Royal College of Pathologists responsible for medical examiners who say that deaths following assisted dying should be notified to the coroner, just as other deaths following the administration of drugs prescribed or not must be.
Thank you for that intervention. I respectfully disagree with that position. I do believe that actually there are already the layers of safeguarding that already exist in this legislation. New Clause 15 is a compassionate and a practical clause which will ensure that the law not only works for the individual making the choice, but also for the family that they leave behind. Moving now to speak briefly on New Clause 5, I would strongly encourage other members to vote against this clause today. Tabled by my right honourable friend, the member for Walsall and Bloxwich, this amendment requires the government to publish a report on any impact this bill might have on civil procedure rules and probate proceedings. On this issue, the Chief Medical Officer, as has already been pointed out, has warned that we are at serious risk of creating a bureaucratic thicket. In my view, New Clause 4 would do just that if passed. Requiring that the government publish such a report would create unnecessary bureaucracy and divert resources without adding any material value. As many members I'm sure are aware, the government has already published an impact assessment on the relevant impacts that they deem this bill could have. There is nothing in the bill that is likely to result in any changes to civil procedure rules, so there is no obvious justification for producing a formal report on this issue. It is important that we remain focused on practical and meaningful safeguards, rather than procedural requirements that are based on immaterial impacts. Introducing extra reporting requirements based on speculative impacts risks creating unnecessary red tape without delivering any practical benefits. Therefore, I urge members to reject this clause and accept no additional reporting in this area is needed. As we rightly scrutinise this bill today, line by line, including nearly 97 hours of scrutiny so far, which I note is more than many government bills, we must keep dying people at the centre of this debate. I speak today in support of New Clause 15, its consequential Amendment 54, and speak in opposition to New Clause 5, exactly for this reason. So we can keep terminally ill people at the centre of this discussion and at the centre of this piece of legislation. No matter where you stand on this pressing matter, whether you support this bill or even if you have some reservations, it is crucial that we collectively ensure that this bill is workable, compassionate and truly centred on the dying person. As legislators, this must always be our chief concern. Thank you, Madam Deputy Speaker.
Carla Lockhart.
Thank you, Madam Deputy Speaker. I rise to support and speak briefly to Amendment A to Amendment 77, tabled by my honourable friend, the member for South Antrim, but will also speak to New Clause 13 and Amendment 96 and other amendments if time permits. I begin by simply saying that I was rather confused when I looked at the amendment paper a few days ago and noticed that amendments which would directly impact on Northern Ireland had been tabled. When last I checked, the bill as a whole extends only to England and Wales, so I find Amendments 76 and 77 perplexing. To be clear, health and criminal justice are devolved matters. The people of Northern Ireland elect their own assembly to make precisely these sensitive decisions. That includes whether or not to legislate for assisted suicide, an issue of profound moral weight and cultural consequence.
My honourable friend and colleague for Upper is right to pursue this, and the honourable member across the way said it earlier on. The NHS was formed by the Labour Party, and it was for the Labour Party, but this amendment that ensures that the City of State can overrule the Assembly members. In other words, 90 members in the Assembly can make a decision, but the City of State can overrule it. Surely that has to be incredibly wrong, and that goes thrust in the face, the very face of the democratic process that we are here to uphold.
My honourable friend is absolutely right. On constitutional basis alone, Amendment 77A is necessary, and I hope my honourable members will feel they can support it. Moving on to factors beyond the constitutional, I'm concerned that there is a danger absence of an adequate regulatory framework for lethal drugs under the bill. At present, Clause 25 gives the Secretary of State powers to approve lethal drugs, while Clause 34 mandates the Secretary of State to make provision for prescribing, dispensing, transportation, storage, handling, disposal and record keeping, as well as enforcement and civil penalties. However, the fundamental issue of how these approved substances are actually approved remains alarmingly weak. The bill defines approved substances simply as a drug or other substance specified by the Secretary of State by regulations. There is no explicit requirement for these substances to undergo specific rigorous testing for their use in assisted dying. When this issue was debated debated in committee, I was disappointed to see good faith amendments to engage dismissed, such as Amendment 443, which sought to mandate that these substances, no, not give way, be approved through the Medicines and Healthcare Product Regulatory Agency and either the National Institute for Clinical Excellence or the All Wales Medicine Strategy Group processes. I therefore strongly support Amendment 96, tabled by the Honourable Member for Slayford and North Heckham, which would, and I quote, ensure that drugs can only be approved if the Secretary of State is reasonably of the opinion that there is a specific consensus that the drug is effective at ending someone's life without causing pain or other significant adverse side effects. This is a common sense approach which should attract support from across the House. This week, more than 1,000 doctors wrote a powerful letter to all MPs to outline their deep concerns about this bill, calling it a real threat to both patients and medical workforce. I strongly urge this House and colleagues to read this letter before third reading. Indeed, the Government's own impact assessment does not provide any comfort with regards to the use of lethal drugs under the terms of the bill, which the doctor's letter picks up on, and I quote, "There is no requirement for the drugs to undergo rigorous testing and approval that would be required of any other prescribed medication, nor indeed for them to be regulated by the Medicines and Healthcare Product Regulatory Agency." They go on to say that this is contrary to all good medical practice. Yeah. And this matters not just for regulation, but also with regards to patient safety and complications. There's no requirement in this bill as drafted to inform patients about how the risks, including prolonged rather than promised peaceful, dignified death, will be managed. Complications do occur, and this is not scaremongering. In Oregon, when complications have been recorded, patients have experienced difficulty swallowing, drug regurgitation, seizures, and have even regained consciousness. In Canada and Canadian associations, patients have experienced regurgitation, burning and vomiting. I also wish to draw members' attention to the written evidence submitted to the Bill Committee by a group of experts, senior pharmacists and pharmacologists. In their submission, they warn that the approach of this bill as drafted puts the cart before the horse. Specifically, they caution against proceeding without a comprehensive review of the evidence for efficacy and safety, and note that this review should be scrutinised by MPs before consideration of legalising assisted suicide. Madam Deputy Speaker, these are not small details of incidental matters, yet even at this late stage in the bill's passage through the Commons, we are still being asked to pass legislation without satisfactory answers to basic questions from experts in the field. It simply isn't good enough. I'm grateful to have had the opportunity to speak, and will close by simply saying whatever mitigating amendments may be passed to this bill remains morally and ethically wrong and is flawed and should not be passed.
John Grady.
Madam Deputy Speaker. I rise to speak to Amendments 8, 13, 82, 83, 85 and 86. But first let me turn to Amendment 77, which extends some of the provisions of the bill to Scotland. My review of the bills in Scotland and England that are proceeding at the minute suggests to me that if someone moved permanently from Glasgow to Bradford or Newcastle, they would lose their right to an assisted death in Scotland, but would have to wait a year to acquire their right to an assisted death in England. Now imagine the heartbreak if you were diagnosed as terminally ill 3 or 6 months into your permanent move to Newcastle. And that's a natural consequence of the law of habitual residence and residence, long-standing case law on that. And one matter that hasn't been addressed satisfactorily is how the relationship between Scots and English law and the Scottish and English law bill will be worked out. And that's something that I suspect will require further primary legislation in this place and in Holyrood if both bills pass. Now I turn to the remainder of the amendments. Amendment 13 is very sensible. It introduces much needed scrutiny and oversight to the appointment of a commissioner. My right honourable friend, the member for Salisbury, has set out in detail the very sensible reasons for the introduction of his suite of amendments. Amendment 86 is particularly important because the panel faces real difficulties in compelling people to come before it if they have relevant evidence, and it seems to me manifestly reasonable that the panel should hear from people who have relevant evidence. I'm also very concerned, Madam Deputy Speaker, that the panel process does not provide a clear role for people who love and care for the person seeking an assisted death. And Amendment 8 requires a panel to actively consider hearing from such people. This addresses a very serious gap in the bill. Madam Speaker, it is important to place the panel process in its proper context. I recognise that there is an important cluster of intrinsic ethical values around the right to self-determination and autonomy, and the right to be treated with dignity. And the justification for assisted dying for many is that people should be able to exercise this right. And I have some sympathy with those arguments. However, there is a further, very, very important question. Will everyone who requests an assisted death be doing so on the basis of a true exercise of autonomy and a true exercise of self-determination? Madam Deputy Speaker, people across our family of nations cannot access good help with their mental health, and good treatment can help people with mental health issues have a fulfilling life even at the end of the life. And I speak of this through personal experience of myself with various family members. And we all agree that palliative care and end-of-life care is not available to many people, and Britain has entrenched poverty, and people worry terribly about money at the end of their lives. It is important to understand, Madam Deputy Speaker, that the panel and the Commissioner do not ventilate or investigate these matters at all, because they are looking at pressure from other people and not those terrible societal pressures. And faced with those terrible... I will, yes.
Honourable friend for giving me. Does my honourable friend agree with me that across all aspects of this bill, we cannot legislate only for those with good mental health, those who are loved, supported, protected? We must have at the heart of this the most vulnerable, those without a voice, those without loved ones with their best interests at heart, and ensure that those people are protected.
I'm obliged, and that is precisely why I joined the Labour Party as a 16-year-old. Faced with those terrible circumstances, some people will seek an assisted death. I find it very hard to accept that these will be truly autonomous choices. We must be clear that the very same circumstances that have denied people self-dignity and robbed them of autonomy throughout their lives will drive them to an assisted death. And I find this deeply troubling. And I worry that we are placing too much confidence in the concepts of capacity, autonomy and self-determination. Now, everyone accepts that coercive control is common. Indeed, it is incredibly common, as is domestic abuse and elder abuse. There are very clear risks of coercion, Madam Deputy Speaker, and I recognise that the supporters of a bill have sought to improve protections to protect people in these types of circumstances. I have anxiously scrutinised these protections, and I do not believe they will achieve their aim, which is why the amendments are so important. However, I will give way.
Honourable friend for giving way. Last weekend, the bill's sponsor posted on X the story of two older people who wanted to die together and found doctors to sign off on their assisted death. Are you concerned that this debate may be romanticising suicide pacts, given that there are, as we know, mercy killings which are unfortunately actual deaths? And do you share the fears of the government's suicide advisor that this bill will undermine suicide prevention efforts?
On that, Madam Deputy Speaker, I think everyone comes to this House debating this in good faith. And in the courts, there's a general view that you should be reluctant to attack otherwise, and I'm sure that question was meant on that basis. I do think, however, that one must not lose sight of the fundamental point, that the protections in this bill will not address the profound societal pressures that people will face. And I think one must not lose sight of the fact that whatever protections are included in this bill, Madam Deputy Speaker, it will not protect people against coercion. I'm obliged.
Mary Calify.
Thank you, Madam Deputy Speaker. Edmund Burke said that bad laws are the worst tyranny.
And over time, I've seen many imperfect measures put before this House, under governments of all persuasions, by the way. And usually, through scrutiny, they're improved. And that's because the parliamentary process works when there's time available, and in particular, where there's pre-legislative scrutiny, independent analysis, thorough thinking about the consequences of what we debate here. That could have happened regarding this important matter, but it hasn't, because it's been shoehorned into a process ill-fitted for its purpose. Now, the amendments that we debate today are a late attempt to improve the bill, and I particularly recommend the amendments in the name of my honourable friend for Rainbow Weybridge, who made an excellent contribution to our debate, the right honourable member for, my right honourable friend, I should say, for Salisbury, and the honourable member for Rochdale. Why do I support those amendments? Because it's critically important that the safeguards in this bill are not only maintained, but improved, enhanced, for all the reasons that have been advanced by members across this House about coercion and vulnerable people. The honourable lady from North Herefordshire said she never encountered coercion. Well, that must be a wonderful place where people carry harps and drink ambrosia. Because in the rest of the kingdom, and I assert the rest of the world, there are many wicked people doing many bad things. And we must never allow those wicked people to have reign and power over those who will be inevitably, because of their circumstances, at risk if this bill is not improved. I will give way, as I cited the honourable lady, to her.
I thank the honourable gentleman for giving way. I'm afraid he's misrepresented what I said. I was contributing an observation from somebody who's been deeply involved in palliative care practice, who reports that it is far more frequent that the dying person wishes to die, and it is their family pressuring them, encouraging them to stay alive as long as possible. So the point being made about coercion, the fears about coercion, appear to be worrying about something that is not actually the case in the cases of dying people.
Well, I'm afraid I disagree. I think there are numerous cases where people will be encouraged, perhaps even forced to take a decision, when they're at their most vulnerable, when they're frightened, when they're doubtful, when they're coping with illness, when they're distressed, when they may be unbalanced. Of course, we have to protect against that eventuality if this bill's to be passed. Now, I will give way very briefly.
The evidence doesn't even suggest, it shows that in the exit interviews in Canada and in Oregon, 35% of those people choosing assisted death in Canada, 47% in Oregon, listed their reason for doing so, that they felt a burden to their family.
John Hayes.
The honourable gentleman, the right honourable gentleman, of course, anticipated what I was about to say, because I have cited exactly that evidence many times during that debate. And we do need to look at the experience of elsewhere to inform what we do here. We always do that when we pass the right laws in this place. But there's worse news, Madam Deputy Speaker, than that. Because rather than being improved during its passage, this bill has in many ways got worse. In particular, by giving additional powers to ministers, to so-called Henry VIII powers. When these two words, delegated legislation, are mentioned in this place, you should always be fearful. When the words ministerial discretion are used, be doubly fearful. And I say that I said that looking directly at the front bench opposite, but I might have been looking at my own front bench. And what this bill does is to give permissive powers to government to make all kinds of changes. And I just want to offer some of them to illustrate my point. This bill empowers ministers to amend the Suicide Act, including the offence of encouraging suicide, to rewrite the principle of the NHS, Section 1 of the NHS Act, to read secure improvements in mental health of the people in England and Wales and end lives of the terminally ill. They can amend the NHS Act to specify this service is not free of charge. This Act only points to the section of the Act that services as provided free of charge exempt, where charging is expressly provided for. They can amend the definition of a registered medical practitioner so it's not a doctor carrying out the assessments, etc., etc. And that's why the amendment in the name of the Honourable Lady for Mitcham and Morden is so vitally important. And the speech she gave was amongst the best speeches I've heard in this House, because the passion she feels for vulnerable people and the difference the NHS makes to them is not only felt on that side of the chamber, as she well knows actually, regardless of the theatre. We all come to this place to ensure that the least fortunate have a voice, that those with less power are given a little more power by our advocacy. So I say to the Honourable Lady for Spen Valley, in conclusion, Madam Deputy Speaker, that there's never been any doubt about the depth of her piety. Now, but let us now be sure about the breadth of her mind, because if she really wants this bill to be passed in a way that is palatable, then she must surely accept the amendments that I've supported and highlighted in this brief, all too brief, contribution.
Members need to be aware that I will be starting front bench speeches at 1:30. So the final speaker, Rachel Maskell.
Madam Deputy Speaker, I rise to move my Amendment 27. The insufficiencies of Clause 25 and use Clause 13 and mechanisms for substance abuse approval has attracted much criticism as it defies safe process. I therefore have taken extensive research with leading academics, toxicologists, anaesthetists and pharmacists and others to understand the safety concerns of the pharmacology prescribing and dispensing. Normally the MHRA would undertake research and trials to secure safety, quality and licensing. BNF focusing on dosage and side effects. NICE, or the All Wales Medicine Strategy Group, on showing that the drug works and is cost effective. This safety regime underpins the reputation of UK pharmacology. So can the House assure itself that without due process, some will have a safe and peaceful death? Let's look at the evidence. First, data is poor. The Health Select Committee visited Oregon. We know there is varying times in which people can die, up to 137 hours. The research cites nausea and vomiting in 10% of cases, seizure or muscular burning, regurgitation and regaining consciousness. There is a lack of consistency of approach and data across jurisdictions, the substance to be used, how they are to be titrated, the dosages to be administered. While ingestion can be a factor, absorption varies according to frailty, metabolism, diagnosis, BMI, and drug reactions. Pharmacokinetics and pharmacodynamics are complex. It has been my discussions with toxicologists, however, which have been most alarming. They have highlighted high risk of acute pulmonary edema. This backed by research showing that 84% of cases on death row using pentobarbital have flash pulmonary edema. This drug disintegrates the membranes in the lung tissue, filling them with fluid, causing shortness of breath and a sense of drowning. As a clinician, I've supported many with this on ITU with such a diagnosis. So high concentrations of this drug will cause acute assault to the cardiopulmonary function. And if paralysed and unconscious, a patient may look peaceful, but is anything but. So such physiological distress needs research. It's unclear how government will identify data process and safety. The risk to those handling the toxic substance also needs examining. And in the light of the government's identifying that a pregnant woman could opt for an assisted death, this clearly needs examination. There's no formulation for safe titration or dosage. If pentobarbital is to be used, as in Australia, the government's impact assessment didn't examine this, so needs revision, but also the drug is not an approved substance for humans in the UK, licensed or unlicensed. The MHRA and NICE have a role to play, and as we are hearing increasingly from professional bodies, they are withdrawing their support from the bill because they know that the regime set out in this bill are just not safe, and that is our duty. Let's all examine the evidence.
I call Shadow Minister Dr Kieran Mullen.
Thank you, Madam Deputy Speaker. Can I begin actually by offering the condolences of His Majesty's opposition for all those affected by the Air India plane crash, including the families of very many British citizens who very sadly lost their lives. Our thoughts, I'm sure, are with all of them. Turning to the bill before us today, as is well understood now, the opposition remains neutral on the principle of whether or not assisted dying should be introduced. That will depend on its progress through its remaining stages in this place and the other place. But I do want to raise two important matters. Firstly, on the question of time. Madam Deputy Speaker, all of us understand the considerable challenges Mr Speaker faces in having to balance the desire of colleagues to speak on this matter with the limited time available for private members' bills. I know Mr Speaker is doing his best to strike the right balance. And a number of members have pointed out that the time being given to this bill is significant and more than that normally allocated to even quite substantial government bills. But I think it is right to acknowledge that this is far from an ordinary bill. It is hard to think of a more deeply consequential and highly contentious piece of legislation for our society. And the reality is, both today and at previous sittings, a number of members have been unable to speak. Speaking time has had an informal time limit, and interventions have necessarily been limited as a result. Debate in this House is not just important in helping us decide how we vote, but is used by the courts to help interpret legislation, and more limited debate limits the scope for this. Ordinarily, a minister would have significant time at the end of a report stage to deal with amendments, provide clarification and explain intention in a way that the sponsoring member of the bill will not. Again, a majority of members may be satisfied with all this, but very many are not. Whilst ultimately the business of this House, what we decide, is determined by a majority vote, how we reach a decision and how we allow alternative views to be explored matters. We should all consider whether we want a debate of such importance to be curtailed in the manner that it has been. So, Madam Deputy Speaker, I would ask the Government to consider whether it could assist the Speaker by making more time available for us to ensure, as we come to the third reading, that we can have the fullest possible debate and every member has a reasonable opportunity to speak and take interventions in the way they would like to. Secondly, members will be aware that the bill before us is extensive but is not the full picture. As others have highlighted, significant elements of how assisted dying will operate are due to be determined by future delegated legislation. The Government's Delegated Powers Memo notes that the draft bill contains 38 delegated powers, including Henry VIII powers, and more powers are contained in the amendments from the sponsoring member tabled for decision today. They include matters such as the content, form and thoroughness of doctors' reports, regulations for replacing or coordinating doctors unable or unwilling to continue, and specifying who will be notified of the panel's decision, which has been raised as an important potential safeguard. These are not trivial matters. These pieces of legislation cannot be amended. MPs can only vote yes or no, and in some cases are unlikely to be debated, and almost certainly not on the floor of the House. It is important for members to fully understand that. MPs often have to weigh up the consequences of rejecting such legislation when they disagree with it because it could leave a void. Members are well within their rights to be content to proceed regardless, and certainly a majority of the committee have presented a bill to the House with the composition as described. That's of course a legitimate choice for members to make. And we've heard debate today about amendments to curtail these powers, and members will need to decide their views on that. But I would urge the Government, in the interest of supporting members, to have the clearest possible idea of how a scheme they are being asked to vote for will operate, to try and provide as much detail going forward as to what these future regulations might consist of. Whilst we won't be able to have all the answers, I think most members would agree it's better that we vote with more detail, not less, even if members are satisfied to support assisted dying in principle. This is something that only the Government can do. I would ask that the Minister reflect on this challenge in his closing remarks, alongside giving the Government's response to those asking for more government time to be given to allow wider debate with more members able to speak. I emphasise again the opposition remains neutral on the matter of whether we should introduce assisted dying, but Madam Deputy Speaker, it's incumbent on us to at least draw attention to matters of procedure that can primarily only be addressed by the Government. I look forward to the Minister addressing the concerns of members along those lines that I've reflected in my remarks today.
I call Minister Stephen Kinnock.
Thank you very much indeed, Madam Deputy Speaker, and I'd like to associate the Government with the words of the opposition spokesman regarding the tragic incident in India. As members will know, the government remains neutral on the passage of this bill and on the principle of assisted dying. We have always been clear that this is a decision for Parliament. However, the government is responsible for ensuring that the bill, if passed, is effective, legally robust and workable. I'd like to start with a brief observation about the process and particularly the time made available to Parliament to scrutinise this bill. This bill has received over 90 hours of parliamentary time, which is more than most bills. Also, more than 500 amendments were tabled and considered in the Commons Committee. I therefore thank members on all sides of the debate for their contributions during the extensive consideration and scrutiny that this bill has received. Turning now to the amendments, given the time afforded, I will confine my remarks to those on which the government has significant legal or operational concerns and to those amendments tabled by the member for Spen Valley to address significant workability concerns. Before getting into the detail, I'd also just like to remind the House that a full list of amendments tabled by the member for Spen Valley, which the government deems essential or highly likely to contribute to the workability of the bill, can be found in the letter sent to all members by myself and my honourable friend, the member for Finchley and Golders Green, on the 15th of May. Turning first to amendments tabled by the member for Spen Valley. New Clause 13 and Amendments 69, 53 and 72 allow the government to create or change legislation to set out the end-to-end process in relation to approved substances to be used for assisted dying. These amendments allow for monitoring and for a regulatory regime to be designed that will offer robust oversight of approved substances and the devices used to administer them, specifically in the context of assisted dying. Amendment 54 and New Clause 15 replace Clause 35, which is currently unworkable in the wider legal context. They align the scrutiny and certification of assisted deaths with the existing process for deaths which are not deemed unnatural. This means that assisted deaths would be scrutinised by a medical examiner rather than by a coroner, unless reported to the coroner by anyone who has concerns about the death. Amendments 92 to 94 ensure that the Secretary of State and Welsh ministers have powers to make necessary regulations to approve assisted dying services in Wales. Amendment 95 brings the Welsh commencement powers in line with the devolution settlement and removes the requirement in Clause 54 for Welsh ministers to lay commencement regulations before the Senedd for approval, to align with usual procedure. I now turn to amendments tabled by other members, which the government assesses as creating potentially significant workability challenges. Amendment 97 would require the MHRA to license the approved substances to be used in assisted dying. This may present workability challenges, as licensing is not possible if the approved substances do not meet the definition of medicinal product under the current relevant legislation. Furthermore, licensing is reliant on the manufacturer applying to the MHRA for a marketing authorisation, for that indication and providing the necessary evidence of safety and efficacy and support. Should the bill pass, the government would work to put in place an appropriate regulatory regime for the approval of substances. It may be helpful to note that the member for Spen Valley has tabled New Clause 13, which recognises the need for a robust regulatory framework to be in place and provides the powers needed to introduce such a framework. Amendments 105 to 107, Amendments A to New Clauses 13 and 14, would restrict the scope of Henry VIII powers available to UK and Welsh governments to make provision about assisted dying services. They further restrict the use of powers in relation to the regulatory framework for approved substances and the devices used to administer them, and the prohibition of advertising. I would point members towards the Delegated Powers Memorandum, which has been published by the government, setting out our consideration of the Henry VIII powers in the bill. As with legislation more broadly, the government recognises the need, in appropriate cases, for amendment by Henry VIII powers. Members will be aware that the Delegated Powers and Regulatory Reform Committee will issue its own consideration of the bill, which will of course be made available to all parliamentarians. Amendment 3 seeks to shorten the commencement period to 3 years. Should this bill pass, an entirely new service with robust safeguards and protections will need to be carefully developed and tested, with input from a range of delivery partners. The government's view is that the bill, as amended during committee with a 4-year backstop for commencement, would be more likely to provide for safe and effective implementation.
Way on that point. One of the key things that's been said by the lead member for Ben Valley throughout this is that 4 years in this bill, as it currently is, would be a backstop. Is that the case then, if he's saying it would take a requirement of 4 years and it couldn't be delivered sooner?
I can confirm it's absolutely the policy intent of the sponsor for this to be a backstop, and the government is working on that basis to ensure it is a backstop, not a target. Amendment 42, I just need to make a bit of progress. Amendment 42 seeks to remove the 4-year backstop. Whilst this is a matter for members to decide, we would note that if both this amendment and Amendment 94 from the member for Spen Valley are accepted, this would mean that nobody would have the power to commence reserved provisions in Wales. This would create major workability concerns for the service in Wales.
One of the advocates of this bill talk about the point of choice and autonomy in deciding when and where a person will die. But can the Minister confirm, do we have enough doctors to provide an at-home service for people to die at home at the time of their choosing?
I thank her for that intervention. I would refer her to the impact assessment, which is of course not a forecast, it's a set of scenarios, and in that impact assessment detail is given on expected numbers and also capacity of the system to deal with the service. Amendments 13 and 82 to 85 relate to the appointment of the Voluntary Assisted Dying Commissioner and panel members. These amendments would put the process for these appointments out of kilter with standard practice for public or non-judicial appointments and could significantly limit the pool of individuals available. Amendment 86 would give the panel the same powers, privileges and authority as the High Court, which are significant in scope and are set out across different court rules and legislation. It is unclear how this would apply to panels in practice, and it may be unworkable given the panel is not designed to be a court. New Clause 4 and Amendment 28 would put various responsibilities on the Chief Medical Officers for England and Wales. Imposing duties in primary legislation on an individual civil servant may cause difficulties in the future if the role does not exist or the title changes. It is usual practice for duties in primary legislation to be conferred on the Secretary of State, who may decide to delegate to the Chief Medical Officer. There were a number of questions directly asked of the government, which I would like to briefly respond to. The member for South Antrim asked about medicines regulation in Northern Ireland. These amendments will not affect the application of EU law. They will instead ensure coherence between the different legislative frameworks, and the sponsor will lead engagement with the devolved government supported by officials. The member for Richmond Park asked about the equality impact assessment. The EQIA considers the 9 protected characteristics alongside socio-economic background, geography and mental health. The member for West Worcestershire asked about the Suicide Act and about advertising. I can confirm that encouraging or facilitating suicide will remain a crime under the Suicide Act, and on advertising, New Clause 14, if passed, would oblige the Secretary of State to make regulations prohibiting certain forms of advertising which promote voluntary assisted dying services. The exemptions to this, which may be provided under subsection 2, will not cut across the criminal offences elsewhere in this bill or in the Suicide Act. I hope that these observations were helpful to members in their consideration of the technical workability of the amendments that we have debated today. Thank you, Madam Deputy Speaker.
Point of order, Kit Malthouse.
Madam Deputy Chair, I beg to move that the question now be put.
The question is that the question be now put. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause 13 be read a second time. As many as of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that New Clause 13 be added to the bill. The question is that New Clause 13 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to New Clause 14, which has been selected for separate decision. I call Kim Leadbeater to move formally that New Clause 14 be read a second time.
Move formally.
Prohibition on advertising.
The question is that New Clause 14 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment B to new Clause 14, which has been selected for a separate decision. I call Paul Waugh to move Amendment B to new Clause 14 formally. The question is that Amendment B to new Clause 14 be made. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Division, clear the lobby. Division. The question is, as on the order paper, as many as are as of that opinion say aye. Aye. As many as are of that opinion, to the contrary, no. No. Tellers for the ayes, Patricia Ferguson, Ruth Jones. Tellers for the noes, Bambos Charalambos, Sarah Owen. Order, order.
The ayes to the right, 233. The noes to the left, 254.
The ayes were 233, the noes were 254, so the noes have it, the noes have it. Unlock. We now come to the question that new clause 14 be added to the bill. The question is that new clause 14 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. We now come to new clause 15, which has been selected for a separate decision. I call Kim Leadbeater to move formally that new clause 15 be read a second time.
Move formally.
Investigation of deaths, etc.
The question is that new clause 15 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. The question is that new clause 15 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. We now come to new clause 20, which has been selected for a separate decision. I call Kim Leadbeater to move formally that new clause 20 be read a second time.
Move formally.
Guidance about operation of Act.
The question is that new clause 20 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. The question is that new clause 20 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. We now come to new clause 21, which has been selected for a separate decision. I call Kim Leadbeater to move formally that new clause 21 be read a second time.
Move formally.
Provision about the Welsh language.
The question is that new clause 21 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. The question is that new clause 21 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. We now come to new clause 1, which has been selected for a separate decision. I call Dame Meg Hillier to move formally that new clause 1 be read a second time.
Move formally.
No health professional shall raise assisted dying first.
The question is that new clause 1 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Division, clear the lobby. That's on the order paper. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Patricia Ferguson, Ruth Jones, Tellers for the Nurse, Bambos Cheryl Ambos, Sarah Owen.